This is week 2 of the sentencing of Nikolas Cruz, confessed Parkland shooter. I'm Janine Stanwood, alongside our legal expert today, Gail Levine, a veteran prosecutor. Thank you so much for being here
Thanks
today.
for having me. This is just my pleasure, unfortunately under bad circumstances.
It's been a week of really some gritty testimony from the state. There is audio, we believe, from the courtroom, so let's take a listen. Dan.
Most of the lawyers are present. The defendant is present. Looks like we're missing a few people from the state, maybe.
They'll be back.
Okay. Can we start lining the jurors up?
Yes.
Okay. Defense? I'm here.
So it appears, Gail, that the jury is not there yet, and we're still waiting for some attorneys to arrive?
Yeah, it looks like maybe some of the prosecution team went outside maybe to talk to some witnesses, maybe to get ready, maybe to get a drink of water, and maybe they don't know the judge has taken the bench. So I'm sure somebody's been sent out to retrieve them so that the judge doesn't remain waiting. She's looking patient now. I don't know how much longer that will last.
We're looking in the audience. Some of the camera shots showed some of the parents that we have seen. Sort of the daily arrivals have been Fred Guttenberg. He's a parent who's been there just every single day. I believe I also saw Joaquin Oliver's mother in the courtroom as well. For these witnesses, for these families, Gail, you were saying this is their choice to be there.
Absolutely.
They think it's important to bear witness to what's happening.
They are part of that prosecution team. They are there to support them. They are there to hear the testimony and to face the person that killed their family member. And they feel that this is their job, their duty, and what they owe to their loved one.
It's hard, though, because the last few days, yesterday, the medical examiner got through victim number 13. So we've heard 13 autopsy reports so far from these medical examiners in just gut-wrenching detail. And although the jurors can see the gruesome photos, these family members can't. But they're listening to the descriptions, and it's got to be really tough for them.
Yes. I see Mr. Marcus is coming into the courtroom, so they must be getting ready. But what I want to say is that the victim counselors that work for the state attorney's office are trained people that know how to talk to victims in a particular manner and offer them the opportunity to step outside during the medical examiner testimony.
Okay, so for example, so those blankets
Yes.
and the cushions that we're seeing,
Sure.
Those are probably being offered by
Absolutely.
the services, right?
That's right.
Okay.
Comfort services. I understand they have 2 comfort rooms where they can escort the victim family members to the comfort rooms. They have therapy dogs there. And so all of these people, obviously, they're outside talking to the prosecution, and they're all coming in. Courtrooms are kept really cold, and those benches are really hard. So we tell everybody, bring a cushion, bring a blanket, and
Cold why? Just to sort of keep the jury awake and alert?
Yes, we used to say it's meat locker time. It isn't always that cold, but for some reason I think when there's a lot of people it gets heated.
All right, let's listen.
No, then we're not. Okay, we're checking on one of the terms.
Sure. We'll wait to introduce that. We don't have to do it while we're done. You want to take the time and look at that?
I'm in there.
Okay, so what's happening now?
I guess there's some discussion between the public defender and the state attorney, maybe about a piece of evidence or the next witness. So sometimes the state attorney will say, listen, we're going to call the next person and give them a heads up to who it is. Sometimes they don't. The judge sometimes requires that.
Just before we start, I need to break between 11 and 11:15 for a meeting today. Does that suit your witness presentation?
That's not going to be a problem, Your Honor. We have 5 witnesses today. I don't know how long those will be. It could be a short day, so
Okay,
as far as our witness is concerned, you can take, not that you need my permission, but
sure.
you can take your time.
Okay, so is it okay with the defense that we're going to take a break for lunch around 11:15, depending on where the testimony is. It's going to be an early lunch, but I have a meeting that I have to attend at 11:30.
Yes, no, absolutely.
I just wanted to let you all know. And then, Mr. Sachs, do you have any idea approximately when you'll be finishing your case?
Probably next week.
Okay, okay, that helps. I'm just trying to get a tentative schedule, and that following week, the week of the 8th, is the week that I have the juror who is unavailable from the 10th through the 12th.
That should be a
And
problem.
then there's another juror on the 9th who has a family graduation that he has asked to attend, although he has said he completely understands if he can't, and that's on the 9th. So if you're finished next week, I was thinking we would have court on Monday, if at all that week, because many of the jurors have conflicts.
That's fine with us.
Is that
The week of the 8th, Your Honor?
correct?
That's fine. I'm sorry. If the state is going to finish,
They said next week.
that's the week of the 1st,
Yes.
can we just not have court on the 8th?
Well, that was my plan.
Oh, I'm sorry.
The plan was if we have the 5th off, which is a Friday. My plan is if the state doesn't finish by next week, then they can have Monday if needed.
I see.
But if not, because of the juror conflicts, we would take a break from the trial for you all to get certain matters taken care of, and that would be an extra week for you all to work on your in-office or in-office matters, okay? So I just wanted to double check to make sure.
Judge, we have to talk about the review at some point. I know we're not doing it now, but I just want to put that on the table.
Absolutely. Okay, are the jurors ready to be brought in?
Yes.
Thank you.
Jurors are answering. All jurors present.
Okay, the jurors are present. Good morning, ladies and gentlemen. State, you may call your next witness when you're ready.
Thank you, Your Honor. Sergeant Reed, Beltran.
Please remain standing for this one. Good morning, sir. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
Raymond Beltran, Beltran.
And sir, what is your occupation?
I'm a sergeant for the Broward Sheriff's Office,
And how long have you been with the Broward Sheriff's Office?
19 years.
Is that your first law enforcement experience with the Broward Sheriff's Office?
With the Broward Sheriff's Office, yes.
Yes. Okay, so I'd like to call your attention to November the 13th, 2018. Do you remember that date?
Yes, sir.
And were you on duty that day?
Yes, sir.
And did you have an assignment that you went to on that day?
Yes, sir.
Where did you go?
I went to the main jail, Pod 4 Delta,
Okay. And what time did you arrive?
3 p.m., I believe.
Okay. How were you dressed?
I was in my uniform, my emergency response team uniform.
Okay. On that date, did you come in contact with the defendant in this case, Nikolas Jacob Cruz?
Yes, sir.
Do you see him in the courtroom today?
Yes, sir.
Would you be good enough to point him out for us?
Sure. He's wearing a gray top and I believe a blue shirt.
Okay. Madam Reporter, with the court's permission, would you please let the record reflect that Sergeant Beltran has identified the defendant in this case, Nikolas Jacob Cruz? So, you came in contact with him at that time, correct?
Yes, sir.
Okay. There's come a time that afternoon that something occurred.
Correct.
Okay. I want to show you now State's Exhibit marked 7A for identification and ask you, Sergeant Beltran, could you identify that?
Yes, this is the video of the incident.
Okay. And is this video, you have seen that?
Yes, sir.
Okay. Does this video truly and accurately depict the actions between you and the defendant, Nikolas Cruz, that existed on November the 13th, 2018?
Yes, sir.
Okay. Your Honor, at this time, I'd like to offer State's Exhibit 7A.
Is there any objection?
Yes, just based on the previous litigation
Okay.
regarding the video. Can we go sidebar?
You mean in the related case number?
Yes, ma'am.
Okay, I remember, but we can go sidebar if we need to.
Okay. Yeah.
Okay, so they're just in a sidebar right now, but wow. So this is Sergeant Raymond Beltran with the Broward Sheriff's Office. This is the deputy who was in the room when Nikolas Cruz beat him up.
Yeah, this is Mike Saps starting strong. You might have got the drone of the medical examiner. There's still more medical examiner to be heard, but he's going to break it up and he's going to show you the true colors of this defendant.
And so he held up the DVD. That's what we call foundational evidence, as I'm learning, right? So this is him identifying this is the DVD that shows the video that you are about to see.
Yes. So lawyers, in order to show things to jurors, have to go through certain steps. We call that laying a foundation. Because the officer has looked at the video, he doesn't have to take the video, he doesn't have to be the one that prepared the video. All he has to say is that it reasonably depicts what it shows on the video and that he was there and he can identify it. If he wasn't there, he may have to have another witness that shows how the video was downloaded, what time it was. But because he's there, just like a picture, he can put it in very simply.
And, the defense throughout the last 8 days has made these objections saying, listen, why do we need to see this? This is too much. Cruz has already pleaded guilty. This is prejudicial, cumulative.
Right. So what the state could have done was showed a certified conviction of this crime, because this defendant pled to this crime. It's battery on a law enforcement officer. It's a violent prior felony. It's prior because it was convicted before, even though he did it after. So it doesn't matter the time period, it matters when he pled. He pled after. So now they're going to show that. Now, Mr. Saps could have just put in a piece of paper that said that he was convicted, a certified piece of paper. But what the jury has to do is weigh each aggravator, and this is prior record or a prior conviction. And that goes to the weight, not to cumulative, but each aggravator must weigh against whatever this defense is going to put into mitigation.
So it doesn't matter by weight. You mean it's not just did this happen, but how badly was it?
Exactly. That's exactly what it is. What do these crimes say about this defendant? The sentencing phase is not about the victims. It is about the defendant. It is what did this defendant do that shows that he is the worst of the worst and deserves the highest crime that the state of Florida offers.
We have not seen a lot of this evidence because it's been gruesome or because it's particularly sensitive. That's something that the judge ruled a couple of weeks ago, that the public would not be seeing some of this evidence. This is already part of public record, so I would imagine that we would see this again. We would see this video. And what a stark contrast, seeing the video, seeing the actions of Nikolas Cruz. We've seen it before. If you're home and watching online, just look on local10.com. We have the video on our website. You'll be able to watch it. The contrast between that and looking at Nikolas Cruz, you can barely see him right now on the right-hand side of your screen.
Right. So thank you. You've given me the opportunity. The fact that his chair is low, that he's wearing the Menendez, what I call the Menendez brothers sweater, that's like to show that he's like a preppy type of kid. He's no preppy kid. You're going to see his true colors in this. I'm not sure that you're going to see him wearing glasses. I'm curious about whether those are real glasses or just kind of fake bug-eye glasses. I know they're jail-issued glasses. They're what everybody wears in the jail, but I don't know what the real prescription is in those. He certainly didn't seem to have those on when he was shooting people. He had shooter glasses. He certainly didn't have prescription shooter glasses, or I'm sure we would have heard from the optometrist that gave him prescription shooter glasses. So we know that those were likely clear if he was wearing any eye protection.
Well, the state, I mean, the defense, I think when we start hearing their opening statements and sort of looking at what testimony they will present to the jury, it'll be about his mental health issues, his upbringing, possible fetal alcohol syndrome.
Right, but what they're trying to do is present to you somebody that's feeble. So when he stands for the jury or he stands for the judge, he is as tall as his female lawyers. If you look at him sitting there now, why is he so short? Because his chair is all the way down to the bottom. It makes him look short, it makes him look feeble, it makes him look younger, it makes him look not mature. This video is going to be able to show the jury in time exactly who he is. And it is going to rebut the subliminal impression the defense is trying to show.
And for those of you just joining us right now, maybe you were not with us for week one, you noticed that these attorneys had these headsets on. Gail, this is really just them doing a sidebar, but instead of walking up to the judge, they're speaking through these headsets.
I've never seen that before. I think it's a great idea. Usually what we have to do is all chime over to the side, and then the judge will put on some kind of white noise so the jury can't hear. And instead, everybody's talking low into a microphone, and this allows everybody to have their notes with them, their computers with them. As you can see, Ms. McCann is sitting there with her computer. She is Michael Satz's legal advisor. She is, I know her, I will tell you, she is a brilliant legal mind. And Mr. Marcus next to the empty chair where Mr. Satz sits, those people are providing notes to Mr. Satz to make his argument. One person only speaks at sidebar, but everybody gets an opportunity to confer.
Let's take a listen.
Mr. Satz, this is going to be published to the courtroom.
Yes.
Okay. And over the defense objection states 7A as an alpha will be received as states 426.
May we publish this, Your Honor?
Yes.
Sergeant Beltran, we're going to publish this. You can just say interrupt to explain what's happening, rather than just have you explain without the video. We're going to play it, and you tell me to stop it to explain what's happening. Okay?
Yes, sir.
There's no sound on this, correct?
Correct.
Is that you sitting at the desk?
Yes, sir. At the table,
Right.
right by the stairs. We're in Unit 4 Delta, Unit 1. Mr. Cruz is walking around doing his exercise like normal. At one point here, he's going to walk around and he's going to flip his shower slides, where he brings them in and he walks with his shower slide folded. So I told him not to do that because I didn't want him to fall. If you look, you can see the shower slide being folded.
On his feet, you're talking about, right?
Yes, sir. Right here, if you want to stop it. That's when I told him. He turned around and asked me, or told me, that his shower slide was broken. So I advised him that he needed to go back inside his cell, and I was going to get the sergeant on the floor to come over and bring him a new pair. And once the sergeant did that, then he can come back out.
Okay.
If you want to pause it now, at this point, he basically stopped talking. He flipped me off twice, and then he attacks me. You get started. All right, if you want to stop. Right here, I'm trying to take control of him, but if you can see, his right hand is going for my taser.
All right. Your taser, do you have your taser with you?
Yes, sir.
Would you stand up,
Sure.
please? Is that where it was?
Yes, sir.
Okay. All right. You sit down.
Okay. So with his right hand, he's going for my taser. He also, with his left hand, tries to go for the taser also, with both hands. The way the taser is in the holster, there's a little button. If you want me to get up, I'll show you.
Illustrate how it works.
There's a little button right here. You got to press the button, you got to rock the taser back, and then you pull it out.
Okay.
How long is it for to see?
Why don't you,
Raise your
now,
hand
can
if
he
you
step
can't, if
down?
you can't see. There's a bunch of you that cannot
Why
see.
don't you step down here?
You have to press this button right here, you got to rock it back, and then you can lift it up. You good?
So you just can't pull it straight out?
No, sir. He could actually lift my whole body.
Okay.
Once he's going for my taser, I immediately had to get my taser back. If you want to go back a little bit, he actually has my taser in his hand. I'll tell you when to stop it. He's going for it right there with his right hand. He also grabs with his left. You can see he's trying to press the button. Right there, he has the taser in his right hand. At this point, I have to get the taser back.
Why?
He could tase me, he can incapacitate me, and he can basically do whatever he wants to me. Also, if he hits me with it, it's a blunt object, he can hurt me. So, all I was thinking right there was get my taser back.
Yes, sir.
We're fighting for the taser right now. At one point, you're going to see a light, and I'll show you.
Hold it.
It's coming up.
Wait, it's coming up fuzzy. Aaron, could you go back?
right there. You can see the light. You see where the table is? You saw the light?
Yeah.
Well, you can see the light. Basically, the taser activated, if you want to stop it. Prior to this, basically, the taser was activated. It was turned
When
on.
you say activated, what do you mean?
It was turned on. So you pull the lever up, and that's when that light comes up.
Okay.
So once it was activated, it was the only way the taser goes off is if you press the trigger.
Okay.
At this point, where we're fighting for the taser, I can't tell you if I pressed the trigger or if Mr. Cruz pressed the trigger. But the taser deployed,
All right.
meaning that the two prongs in the front shot out.
Okay. So explain how the taser operates.
Okay, there's a cartridge in the front. When you press the trigger, two prongs come out, and they're
Are the
intended
two
to hit.
prongs attached to anything?
Excuse me?
The prongs attached to anything?
To the body.
Okay.
Like when they deploy, the intent is to hit one and one, and then it does the job.
Okay.
So it deployed onto the floor. So that's when you see that light.
So, stop for a second. So when you say deployed, the two prongs or two darts shoot out and they
Correct.
hit your target, right?
Correct. That's
And
on a
then-
normal.
Right, right. So I'm just trying to get the explanation how a taser works, or this taser works.
Correct.
So it goes out as attached to anything, wires?
They're connected to the taser.
Right,
So the wires shoot out with the
Right.
two prongs.
Right.
It connects to your target.
Right.
And then it does what it's supposed to do.
okay. And when you pull the trigger, what happens?
It cycles for 5 seconds.
Okay,
While you have, on this particular taser, while you're pressing the trigger, it'll cycle for 5 seconds and it'll stop.
so electric charge goes out to incapacitate the person, correct?
Correct. For 5 seconds.
All right,
Then, if you want to continue another 5-second cycle, you're supposed to press the trigger again.
okay. And you can press the trigger continually and,
Yes, sir.
so 5 seconds, 5 seconds, 5 seconds. 5
Correct.
seconds. Okay, okay.
So right here, basically, he got in a fighting stance, I got in a fighting stance. He took a couple punches at me. He missed. I hit him one time. I had the taser in my hand. I struck him. He moved back. Then he got on the table. I told him to face down. I put the taser on his back. I handcuffed him.
Okay.
I took him back to the cell, and
Okay. Okay, and that was the end of that?
yes, sir.
Okay. So with the taser, what type of training do you have, or did you have with
We
that?
go through the taser class, which is an 8-hour course. We get explained everything about the taser. Once a year, we do a refresher where we deploy against like a dummy
Okay,
once a year.
okay. And you carry that on your uniform all the time, correct?
Yes, sir.
Okay. That's all I have, Sergeant Beltran. Your Honor. Thank you.
Okay, do you guys have any questions?
Yeah, I mean, we have a sidebar.
Sure.
Okay, that was some pretty powerful testimony to start off with
Yeah.
today. That was Sergeant Raymond Beltran with the Broward Sheriff's Office. He was the sergeant in the jail when that attack happened in November of 2018.
Yeah, November of 2018, which is, sometime after the crime. He's had an opportunity to acclimate in the jail, to know how it is to act appropriately. And to me, that looked like he was baiting the officer. He was walking. He was using his shoes improperly. The officer told him to stop it because he didn't want him to slip. You saw there was a little slip that he did make.
Yep.
And then when the officer told him, you know, listen, you're going to go back to your cell. I'm going to get you another pair of shoes, which was pretty nice of him.
Sure.
The rage just comes flying out. And that is, you know, that is who he is. You don't affect his ability to be the authority figure. That's what that weapon of mass destruction was that he had in his hand, and that is who he is. He is going to be the one that's in charge.
And in this, the prosecutor Mike Satz had him get up, go into the courtroom, go onto the floor, and actually show where Cruz tried to grab at his taser, which could have injured him or others in that jail cell. And so that was effective, of course. He didn't have to do that.
No, but I think that was finally, Mr. Satz got somebody up out of the witness chair and made that a little bit more human than just a witness sitting in the chair. And you also got to now really look at the physique of the officer and how he looked. And let's put it this way, he's not in bad shape, but he's not winning the Mr. America contest either. So he's just a regular kind of guy, and he's going to rely on that taser for his safety. He's not going to rely on brute force. He's going to rely on, you know, his means of preventing harm to himself or anyone else.
And so it was interesting because this video, we've seen this video before. It's been in the news. It's been part of
Yeah,
public record. We've shown it, but to see it and having it narrated by the officer who was there, we saw a shot in the courtroom of Max Schachter, one of the parents who's been there just about every day. I mean, his mouth, he mouthed wow, wow when he saw that. Yeah. I mean, he's seen it before, but I think to see it again and to hear this BSO sergeant recount what happened, to pause it exactly at the moment that he flipped him off twice and then right before he went on the attack was something else.
So I think this finally puts that crime in context. When that crime was being discussed as they were picking the jury, and everybody said, especially in the law enforcement community or in the legal community, oh, it's just a small crime. You know, people, you know, hit cops all the time. Well, no, not like this, number one. And number two, this shows who he is.
It's interesting. I mean, there's so many different strategies. You've been a prosecutor for 35 years. You've tried capital cases. So why now? Why have the jury see it now? You could have opened it up with them seeing this video.
I don't think this could have been placed any better, because you had all these autopsies. You had all of this carnage that you saw, contact wounds. And now you know why there's a contact wound. Because, unfortunately, there are some people that are just born evil.
And so the thinking is, we're hearing about the damage that was done to these victims. Now you're seeing Nikolas Cruz in the flesh, actually
random acts of violence,
actually attacking somebody at close contact.
Right. Somebody that didn't do anything to him. Somebody that was willing to get him a new pair of shoes. You know, but what I think the defense is going to do, and of course they have to try and turn that around, and they have to say, look how troubled he is. Mm-hmm. He doesn't like authority because he's troubled by it, and there'll be a psychologist that comes in and that will probably explain this as, well, that's a fit of rage because he's incarcerated and he's had some rights taken away from him, and he's frustrated because of his immature nature, his brain not being fully formed. I don't know. His brain looked fully formed for war, but that was...
Well, of course you say that. You are a prosecutor through and through. Maybe a defense attorney would argue differently. But so I think that's you know, that's something that the jury is going to weigh very heavily.
Let's put it this way. I don't think the jury expected that. I mean, these are people that aren't supposed to know a whole lot about the case, and I don't know whether they knew that battery on the law enforcement officer that was in the news some time ago is now related to this, but now the light bulbs come
Sure,
on.
sure.
And
it is true. We in the news business, we remember these things, but you know, people have lives, they have families, they're not paying
They don't
attention
remember it's
to
the same person.
everything. Sure. So what are they discussing now? The defense has already made their objection, right? So
Right.
what's the sidebar do you think this could be about?
I think the sidebar is that, you know, they feel maybe possibly the state went too far. They want a mistrial.
And this is standard stuff that they're going to bring up.
Yes, they're going to do this every time, and they have to. They're doing their job. Don't think for 1 minute these are not experienced people. These are highly experienced, trained lawyers that have been to all kinds around the country. They use the Colorado method for picking a jury. They've been to that forum where they teach defense attorneys to pick death penalty juries. They are schooled and they are good at it. I respect them wholeheartedly for what they're doing and how they're doing it. So they must make these objections, or the objections will be deemed waived. So they are required to do their job.
And what was explained to me by your friend David Weinstein, who's also been here as our legal analyst, and
My
by
old
the
trial
way,
partner, may I
yes,
add?
So grateful to have both of you here with us to offer this perspective. This is also what they're doing is not just their job right now, but if and when there's an appeal, these objections are then for the record, so that down the road,
Correct.
it's not okay. Well, you didn't, and so you waive that right.
Listen, this case is going to go on for eternity, and until some governor signs his warrant and some Supreme Court says it's time. It's going to be time. And I know what people are saying. It's a waste of time. I've been to death row. I've been to an execution. It is not a waste of time for the families. It is not a waste of time for the public. And it is not a waste of time for the defendant to make sure that everything was done properly in his case. So the series of reviews do take time, but the time is well spent. I do want to correct myself. I see there was a pair of glasses there. I don't know when he got those glasses. He seems to have, it doesn't appear to be the officer's glasses. It does appear that there were glasses that were thrown off the face.
It did.
Yes, so
right,
I want to
because
correct myself.
Sure.
that-
I mean, the question is, right, when did he start wearing these glasses? Because I don't think we saw him
Right.
wearing those glasses in earlier photographs. But.
Right. And again, they can get him glasses early on to start wearing. They can do lots of things. You know, they can ask him to lose weight. They can ask him to, you know, that's his case. This is his case. They can say, you know, what do you want to do to make yourself look better in front of the jury? And we can't just do it the day before, because somebody like me is going to say, oh, look, he just got a pair of glasses.
Right.
So maybe he does have an eyesight problem, but certainly on the day of the crime, whatever he used, he saw very clearly 34 people.
Right. So they're discussing right now. Earlier today, when court was in session a little bit after 9 o'clock, there were some housekeeping things, and the discussion was how many more witnesses, when do we think the state is going to wrap up? Mike Satz had indicated that he had 5 witnesses today, so this is one of the 5, this BSO
Yes.
sergeant, and that possibly next week the state could be wrapping up.
Yes.
And does that include the victim impact statements?
Well, see, now they've proved another aggravator here. They've approved, they've added to the weight of the attempted murders. So I just want to be clear why they did this and why they needed to put this on was because they have 17 attempted murders. Again, that's a prior record, something he pled to before. They've proved that by bringing 17 people in. Now they're going to bring an 18th portion of that aggravator. So that aggravator is now weighing very heavy. So what's going to happen now? Mr. Satz is going to wrap up probably today, maybe some more medical examiner. Tomorrow they're off, Thursday they're off, Friday they're off, and he says he's going to come back with some more evidence next week. I would imagine he's going to finish with what is really not evidence, but by the Constitution of the state of Florida, allows any victim that wants to come up and not say whether they want the death penalty or not. You will not hear that. You will hear prepared statements of the victim's impact on their family and on the community, what the loss of their life has done to the community and to the family. So you will hear possibly 17 of those. That could go on for a period of time. When they're done with that, the judge said if they're not rest their case at that point, that is part of the state's case, cannot be argued in evidence, cannot be argued in closing. Oh, you heard Mr. Guttenberg say this. That cannot be argued.
Okay.
But when they finish that portion, which is their portion of the case, the judge said she's going to take a week off for people's schedules. And again, that was built in during jury selection because some of these jurors, as she said, already told her that they were not available for personal reasons next week. They happened to come out on the same week.
And there's also a hearing, a Daubert hearing?
Right, an evidentiary hearing that will determine whether a test performed by one of the defense's experts called a QEEG is going to be allowed, and that's basically brain mapping. And it's a brain mapping test, so to speak. It is not widely accepted in the medical community. It is used in the legal community. Sometimes we use things from doctors that we like, and sometimes we use things from doctors that we don't like.
Sure.
The state has fought vigorously in this manner because the state believes that this is sort of like a voodoo science.
Is this related to, because there was also an issue with one of the potential experts who was an expert in fetal alcohol syndrome, but that witness, I believe, had a medical issue and had to retire, so there were some questions about her as well. So I don't know. So I don't know if this is one and the same, or if these are two different experts.
I believe that they're different experts because this would be somebody that actually performs this test. It's sort of like if you went for an MRI, it's sort of done in the same manner, and then it comes out with a photo of your brain, and what's problematic is that they colorize it. So, you can put red and blue, and what does the red mean? What does the blue mean? Well, subliminally, we know what those means. So they'll be arguing about all of that. In Miami-Dade County, the judges have not allowed that on death penalty cases, but and it hasn't been fully litigated throughout the state. So this will be a big hearing for them. I wouldn't be afraid of the evidence if it comes in. I think that it is... you can show what kind of science it really is. Some people may be swayed by it. And if they are, that goes to the mitigation, and that's why they're going to put it in.
Sure. So these will be discussions that will be had in those 2 weeks that are being built in before the defense then makes their openings.
Right. And like you said before, why are they going to object, the state? Well, because if they win and the defendant gets sentenced to life, they could cross appeal on that. So they would be allowed to get a final resolution on that, and the defense would say, we should have been able to put that in. If the appellate court thinks they should have been able to put it in, this would have to be a redo. One
thing to remind our viewers, if they're just joining us or if they needed a refresher, Gail, this is a recommendation by the jury. The jury can recommend the death penalty unanimously. It has to be unanimous. But the judge, under Florida law, could say, well, I think actually what is more appropriate is life. But it cannot be the other way around. That's right. So it's actually a one-man veto for the jury. The state must have the jury 12 people individually and 12 people as a group recommend the death penalty together. It's a unanimous decision. For all 17 victims, by the way. Each particular count.
Correct. Right. So what happens with that is if one person is a rogue juror and really doesn't believe in the death penalty, they could stand firm and be the one-man veto, 11-1, 11-1, 11-1. If it's 11-1, the judge cannot sentence the defendant to life. The law does not allow it. Right. To death. I'm sorry. Yes, to death. If it is 12 unanimous for death, she can override that. Shall we not forget she's an elected official? In Broward County, I can't imagine she would ever override that. Well, maybe she believes the aggravators outweigh the mitigators also, which is what she has to make that finding as well. So that won't be, when they say this is going to go on for a long time, there's going to be this hearing. If there's a 12-0 recommendation, there's going to be something called a Spencer hearing. They're going to bring in, the defense is allowed to bring in things that they weren't allowed to bring in before, or they chose not to. That's going to be just in front of the judge to try and change her mind. So it's going to be A process.
A process before we know what exactly will happen to
But again,
Nikolas
if it's
Cruz.
11-1,
Ladies and gentlemen,
it's
we're going to
over.
take a short recess. Please do not discuss the case among yourselves, and please leave your notepads behind.
Maybe we'll get some insight now.
Right, maybe we'll get some insight as to what that sidebar was all about. Short recess so we can listen and see if there's anything that the attorneys are speaking about once the jury leaves.
Oh, isn't that?
If you wouldn't mind just stepping outside while I have a conversation with the lawyers. Please don't discuss your testimony with anyone.
Yes, ma'am.
He's a correction officer.
Okay, so we are still listening in to see what the discussion will be between the judge and the attorneys. As the jury leaves the courtroom, she says this will be a short recess. We do understand that they're going to be in a recess again between 11 and 1:15. She says she has a 11:30 meeting. She wants to give the jury time to have lunch and then to come back. So we just heard from this one witness, witness number 60, Sergeant Raymond Beltran, who was the officer who was inside the jail area where Nikolas Cruz was pacing, and then the attack happened. There was a sidebar, kind of a lengthy sidebar, and then the judge just ordered a brief recess. And I don't think, is there audio coming from the courtroom?
I don't hear any. Oh, there
There is some. Okay. Well, we're not hearing any discussions yet. So,
No. But if you look at him here really closely, he really doesn't look like a child. I mean, if you look at his facial features.
well, he's wearing a mask too, which may be part of the strategy not to reveal too much of his face.
Maturity.
You can see the Dwarettes. You can see the Hoyers. Fred Guttenberg is there. These are some of the family members who have been there just about every step of the way.
I don't know whether the judge is reviewing the video again.
Well, I mean, I guess what else could she be reviewing?
On the rulings on this video and these matters. So your first argument is that you want to impeach the sergeant with the reckless driving conviction that he concluded his probationary sentence 2 years ago. Is that correct? Is that the length of time that you said, 2
He was
years?
on probation for 2 years, but that period expired.
But you want to be able to ask him whether or not, why don't you tell me rather than me telling you, so I can make sure I understand.
Judge, I think the argument posited by this meal was that that we should be able to show that Sergeant Beltran has a tendency not to follow standing operating procedure with the Broward Sheriff's Office, and in doing so, while he was on duty on an extradition assignment, he picked up that he was arrested for a DUI.
Okay, is there any evidence that during this incident or altercation with your client that the Sergeant Beltran was not following standard operating procedures?
I mean, besides myself testifying, Judge, I can tell you that he wasn't following SOP allowing him to walk around continuously around the tables. When he's in the day room, he's supposed to be seated.
He was not allowed. Can you say that again, Mr. Miller?
When you're in the day room, you're supposed to be seated according to standard operating procedures.
All right, and what is the second argument you wanted to make, or second point of cross-examination?
Judge, during the pendency and preparing the litigation of this case, Sergeant Beltran appeared for deposition. He followed subpoenas as directed. He made sure that he was there on time, because if he didn't, he was under the threat of imprisonment by violating the conditions of his probation in Washington State.
Do you have any evidence that he had a pattern of not showing up when he was subpoenaed for
No.
deposition? So you want to be able to ask him if the only reason that he showed up is... And first of all, using prison for... Can you go to prison for reckless driving in Washington?
I said imprisonment, Judge.
Imprisonment.
Threat of imprisonment.
What's the maximum penalty for reckless driving?
I'm not sure what it is in Washington State, ma'am.
It might not even be jail time. You need to know that if you're going to ask him that, don't you? All right, what else?
It's up to one.
In the state of Washington. Because I can tell you in the state of North Carolina and other states, those kind of things are very different. And some are not even considered a misdemeanor or felony or other.
Does that have a statute? It carries up to 364 days in county. And a fine of not more than $5,000.
And what was the third area you were saying about the video?
Just that we don't have the remainder of the video as been previously litigated by motion to dismiss because it was not preserved. So we don't know what happened just prior to this incident.
Your Honor, if I could just add a point, that the rule is that you can't ask a police officer if he's, or a witness, if he's still on probation at the time he is testifying. The rule isn't that you can ask a police officer or a witness if they've ever been on probation during the pendency of the case. That's not what the law is. That's what the defense wants it to be, but that's not what the law is.
So what's going on here?
So it appears that the officer had been arrested in the state of Washington for a possible DUI. It appears that he pled to a lesser charge of reckless driving. And in the state of Washington, having looked that up, that is a misdemeanor. It is not a felony. So two things. Number one, because it was a misdemeanor, the Broward sheriff put him on 2 years probation.
And was he on probation at the time of this attack?
It appears that it was subsequent.
Okay.
But at the time that he gave his deposition, he was on probation.
And so is the thinking from the defense he's not reliable, he's not acting in accordance of BSO policy?
If you have been convicted of a felony crime or a crime of dishonesty, whether it was a misdemeanor or a felony, that can be brought up by the defense in impeaching, because there is a jury instruction that says if a witness has been found to be convicted of a crime, you can take that into consideration and use it in the weight of their testimony. So what they're trying to do here, the defense is saying, listen, because he's a cop and because he was on probation and because he gave a deposition while on probation, we should be able to show his bias, that he was on probation and thereby basically making his testimony better or doing something to be better to keep his probation going strong so he'd get off, so he would get off the probation. However, every witness has to be treated the same, and any witness that was convicted of a reckless driving that would never be brought up before a jury. So I'm kind of confused why the judge is struggling with this, because she's already said at the sidebar that he came to the deposition on time and that there's nothing that he said that's different than was shown in the video. So they have nothing to impeach him on.
And keep in mind, if you're just joining us now, this is not something that the jury is hearing. They've been told to leave the room.
Right.
The family members initially, I think, were going to leave when they were told that there was going to be a break. But once they started hearing this, they're all back in the courtroom. So let's listen. Okay, so usually now when we see the seal, although I'm not sure if that's just a camera shot issue, but that means that open court is done, or at least for right now.
Yeah, maybe the judge left the bench to do a little legal research herself to make sure she's going to make the right ruling. I don't know. I didn't see them stand, so I don't know if she remained on the bench. If the judge was to leave, they would all stand. I didn't see them stand.
We did see some members of the defense get up and walk
out. And we see the prosecution team sort of sitting back, not being too, concerned either way. They look like regular day at the office.
Right. So, just to recap, we just saw some pretty stunning video. Even though we've seen it before, it was a reminder of what happened in 2018 when Nikolas Cruz was convicted. He pleaded guilty to beating up this BSO sergeant inside of a jail. We saw that video again. We saw that sergeant get up and actually demonstrate where Cruz reached for his taser. An extremely dangerous situation and very powerful testimony, powerful video, and then all of a sudden all of these sidebars. And we've learned that there was an issue with this sergeant.
So the question really is, if this evidence comes in that he was convicted of reckless driving, because it's got to be about the conviction, and that he was put on probation, which allows him to keep his credentials as a police officer, did that conviction change anything that you saw in that video? Maybe somebody might think, well, he's an aggressive guy himself because he drives aggressively.
Or maybe he wasn't credible in describing what happened because of his prior issue.
Or maybe there was something between them before that caused Cruz to attack him. Maybe he taunted him before. Maybe that's the kind of guy he is. I don't know whether they have any evidence of that. But certainly if he had been convicted of a felony crime or a crime of dishonesty, like perjury, that could have been brought up, and I'm sure Mr. Satz would have brought that up in his case.
Sure.
This is something that they want to bring up, the defense wants to bring up in cross-examining him. And there is case law that says if the charge of the officer is attenuated, meaning it really doesn't have anything to do with it. What does reckless driving have to do with this? The court should not allow it in, because, once again, it is not relevant pursuant to the rules of evidence. If he was on probation for a felony, we'd hear that he was on probation for a felony. Any witness, we would hear that, police officer otherwise. And there's nothing that says a police officer should be treated any different than any other witness.
Well, we are going to continue to monitor this. My colleague Christina Vasquez, she's in the courtroom right now. She is listening. She's watching. We will be watching too. And of course, as soon as court resumes, as soon as there's audio and video from back inside the courtroom, we'll be back as well. Welcome back. This is the sentencing of Nikolas Cruz. There was a brief recess. Let's take a listen.
Professor Earhart's Florida Evidence Guide. And my rulings are as follows. The general rule, as you all are familiar with, is that a witness can be impeached with a prior conviction for a crime of dishonesty or false statement. And the only exception to that is when a person is called as a witness by the state and the person is either under investigation, under an open criminal prosecution, or the person is under supervision, such as probation, community control. And that is for the sole purpose of being able to show through that witness that the witness is trying to curry favor with the state because of the witness's current situation. In this situation, Sergeant Beltran was, I don't know if he was convicted or not, withholder, but I don't think it matters, because it would be admissible if he was on probation or if there was an active pending case against him. But the fact that he is no longer under supervision, the exception, the very limited exception that allows for questioning of an open investigation to show that the witness is currying favor, or perhaps currying favor, does not exist here. And so I don't believe the mere fact that he's a police officer makes it wide open for all of these other reasons. I think that the rules of evidence are clear that when a crime is not a conviction and or it doesn't meet the standard for a crime, it is a conviction but doesn't meet the standard for a crime of dishonesty or false statement, or it's not a felony, it's a very limited situation when you can bring it up. And I don't believe that that situation and those factual requirements are met here. So I am not going to allow you to cross-examine Sergeant Beltran on this reckless driving matter from the state of Washington. And that includes, your argument was that the bias, he was biased and that he appeared for depositions only because he was facing these charges in Washington. I agree with the state that the bias has to be a current bias. You can't question about a bias that happened at depositions several years ago. In addition, when it comes to any type of impeachment on this video, I have reviewed my prior order as well as my notes on the hearing. And the video preservation or lack thereof had nothing to do with this witness. It had to do with his superiors. So there is absolutely no relevance in asking this witness about video preservation, which was not part of his job responsibility, and he may not even know the answer to. He may, but I don't believe that that qualifies as impeachment material either. And finally, I had mentioned the possibility of just asking questions. If your contention is that this incident may have met the requirements of self-defense. However, after refreshing my memory as to the hearing in 18-14129, I found that there was absolutely no showing that the material on the pod video from the day showed any interaction between the sergeant and the defendant. That the video was not material, it was not exculpatory, and that that the pod video prior to, there's I believe 5 minutes prior to the incident and 2 minutes after the incident were preserved. But I did find previously that the pod video, any other pod video, would nevertheless be irrelevant to any claim of self-defense. If the defendant were to assert a claim of self-defense in this matter, any perceived threat on the defendant's part as it related to Sergeant Beltran would have to be imminent. And the pod video of the entire day would be irrelevant to that fact. And the moments leading up to the altercation were captured on video and represent the only time that would be relevant to a claim of self-defense because of the amount of time. So I don't know if your intention after he pled guilty is to try to assert a claim of self-defense.
I don't think the defense has mentioned that at all, Judge.
Well, you were mentioning the video, and I wasn't sure where you wanted to go with the video questioning. So I'm just bringing that up, that I have already determined that any pod video that is not available, number one, has nothing to do with this witness, and number two, would not be relevant to any claim of self-defense. So with that, can we bring the jury back in and the witness in, please?
Okay, so the fact that he was arrested for DUI will not be something that the jury will hear.
Right, just like any other witness, and he wasn't on probation today, so he's off probation, so it's never going to come in and the jury's not going to hear it, just like any other witness. He's treated just like any other witness. The video preservation, there was some question about whether it was not preserved later on properly, and I believe the judge found that was not part of his job responsibility, so he couldn't be cross-examined on that. She also said that they couldn't bring in prior video from him earlier that day because a couple of reasons. First of all, she found that no threat to him was imminent, so he couldn't use self-defense at the time that he did this. And what she didn't say was he pled guilty.
Right.
So he can't say use self-defense now.
Sure. So do you think, is the state breathing a sigh of relief?
Well, listen, anytime your objections are, the defense objections are overruled, you breathe a sigh of relief. You never know whether the judge gets a wild hair. I thought it was very telling that the judge went back and used a very important book that all of us usually have on our counsel table. It's The Rules of Evidence by Earhart, and she quoted Earhart. And so she went back, she did her own legal research, and I give her a lot of credit for that.
Well, so the jury has seen the video. They've heard from this witness, this BSO sergeant. What else is there? Will he be excused, and that'll be that?
Well, I think we'll
know if
see
there's more
whether
testimony.
I think she kind of annihilated the defense's cross, so we'll see.
If you all want to be seated for a moment, and the bailiff will announce when they're entering.
Well, we thought this particular witness was going to be a quick witness. Show the video, have his testimony.
And then you have a legal argument that lasts 30 minutes.
Jurors are present. Everyone may be seated. Mr. Wheeler, whenever you're ready.
Good morning, Sergeant. How are you doing?
Morning, sir.
You mentioned the taser during the incident, right? Like the one you're carrying now?
Correct.
Would you agree with me that the taser you're carrying now weighs slightly less than, say, I don't know, a stapler?
And a stapler?
Like a stapler, like you would find on the judge's desk.
Sure.
Okay. And the taser that you carry it because it's considered a non-lethal instrument, right?
Correct.
So going back to 2018, from the moment that Mr. Cruz is brought into the Broward County Main Jail, he's kept in his own housing unit, right?
Correct.
So that's 4D1?
Correct.
I think when he first started, he at least had 2 officers with him at all times.
I don't recall, but you could be right.
Okay. Well, at least since then, he's had at least 1 BSO deputy with him.
Correct.
Is that true?
Yes, sir.
Is this any old BSO detention deputy that's with him, or is it some
I'm sorry,
specialized? Is it a specialized deputy that's with him?
I don't understand what you're asking me.
A member of the ERT.
Yes.
What is ERT?
Emergency response team.
Okay. And so the only these deputies are working this detail, right?
Correct.
Besides this physical fight with you, the only person Mr. Cruz has ever hurt in the main jail has been himself. Is that true?
Himself?
Yes.
I don't know.
You don't know?
If he's hurt himself,
Yes, sir.
I don't know.
Were you aware that he was placed in suicide watch multiple times?
Yes,
Okay. And why do they do that?
for his safety,
Right. So he doesn't hurt himself, right?
correct.
The injuries that you received during this fight, they were classified as superficial, is that correct?
I don't remember.
You don't remember?
I don't know if they were superficial or not.
Do you recall photographs being taken of your injuries?
Yes, sir.
And do you recall there being any bleeding?
No, I do not.
Do you recall them putting on bandages on you?
I chose not to have medical attention.
Did you go to the hospital after work?
I chose not to.
So the video that was played for the members of the jury doesn't show what happened just before the incident, right?
Say that again.
The video that was played for these jurors doesn't show what happened just before the fight, correct?
It doesn't show what happened before the fight?
Yes.
It did.
Okay.
He walked around.
So, correct me if I'm wrong, but it showed him pacing around the tables.
He's exercising.
That's his exercise?
That's what he would do, yes, sir.
And how long was he doing that for?
That day?
Yes. Or just before the incident?
Probably probably 20 minutes, maybe.
All right, so
If I
just 20 minutes walking around in a circle.
Correct.
Isn't it true that after this incident, you lost your status on the ERT?
Lost my status?
Yes, you were taken off the emergency response team.
I was never taken off.
You were never taken off?
No,
Were you assigned to administrative duties?
I was.
And how long did that last for?
2.5 years, maybe.
Since then, have you been tasked with guarding one-on-one Mr. Cruz?
No, sir.
Judge, can I have a moment, please?
Sure.
So he's saying it without saying it?
Well, I don't think so. I think that he tried to make a couple of points. First point was that the weapon is light. Well,
Okay, thank you, sir.
that's the reason why they carry them. They're
Sure.
light, but they're forceful.
The taser.
Correct. And he was trying to indicate that there was something before that, like kind of put out a piece that maybe there was some argument before, which was what they wanted to show, and the judge didn't let them. But the witness pretty much held his own and said, you know, you saw before what happened. He's
Right.
pacing around and what they call exercising. And it's not unusual if you look at jail videos, they exercise in all different ways, especially if they don't have time to go outside that day. You know, they get certain times during the week that they go outside. That doesn't mean they're going to sit in their cell. They're going to go into the middle of the pod, they call that area a pod, and they're going to walk around. They're going to run around. Sometimes you see people actually running that pod in a circle, and many times. Lots of people do it. They do jumping jacks. They do all kinds of things. So it's not unusual to see somebody, so to speak, exercise like that. Obviously, after this being so high publicity, they took him off of that detail. That detail has lots of high profile defendants in there. So they don't want him to be in that situation again. They take him off, and he did what most other sergeants do, administrative duties.
Gotcha. Well, this is, I believe, our next witness. It shouldn't be a long witness because we're supposed to break at 11 o'clock. So
I think
let's take a listen.
The whole truth and nothing but the truth?
Yes, I do.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
My name is Kevin Forsberg. Last name is Forsberg.
And your occupation, sir?
I am a deputy sheriff with the Broward County Sheriff's Office, currently a sergeant in charge of the homicide unit.
Okay, and how long have you been with the Broward Sheriff's Office?
Approximately 21 years,
And how long have you been in the homicide unit?
going on 12 years now.
Okay. I'd like to call your attention to Wednesday, February the 14th, 2018. Were you on duty on that occasion?
Yes, I was.
Okay, and on that date, did you have an occasion to respond to a certain location?
Yes, I believe it was about 2:35 in the afternoon. I was notified by my sergeant, which was Jonathan Brown, to respond out to the shooting that occurred at Stoneman Douglas.
Okay, Marjorie Stone Douglas High School in Parkland, Broward County, Florida.
Yes.
And what time did you arrive?
I got there about 3:05 p.m. and it was still an active scene at that time.
Okay. And did you have an occasion to go into the 1200 building?
Yes.
Okay. I want to show you now State's Exhibits 22W, 22V, and ask you, Detective Forsberg, if you can identify that.
Yes.
What is that?
These are cell phones that were located in the east stairwell, first floor of the 1200 building.
Okay. And showing you now State's Exhibit. Already been introduced in evidence, 255. Is that on everybody's screen? Okay, you recognize that?
Yes.
Okay, what is that?
That would be the same cell phone that we located and eventually ended up recovering and identifying it as the phone belonging to Nikolas Cruz.
Okay, and showing you State's Exhibit 256. Is that another shot of that?
Yes, that would be the same phone.
Okay, and now showing you, Eric, this time I want to offer State's Exhibits 22B and 22W.
Is there any objection?
Amen.
Without objection, states 22V, like Victor, will be received as 427, and states 22W will be received as 428.
Detective Forsberg, I'm now showing you State's Exhibit marked 23B. Ask you, sir, if you can identify that, please.
Yes.
What is that?
This would be the evidence bag that I prepared and submitted this cell phone in and sealed up and provided to Detective Valerian Perez after locating it.
And that's the same phone that's been depicted in State's Exhibit 256, 255. Amen. 428. Right? Sorry?
What did you say that was there?
I can hear you.
What number did you say that was?
428.
Thank you.
428. And 427. Correct?
Yes.
Okay. Your Honor, at this time, I'd like to offer State's Exhibit 23D.
D as in Delta.
Yes, ma'am.
Is there any objection?
That's the actual phone?
Yes.
Just pursuant to the suppression issues that relate to the cell phone, but other than that.
No objection.
Okay, let me speak to the lawyer's sidebar, please.
Okay, so it's hurry up and wait, I guess. This is Sergeant Kevin Forsberg with the Broward Sheriff's Office. This is, Gail, what you and David have described to me as a piece of foundational evidence, right? That's the
Yes.
cell phone?
Right. So what they want to do is there's obviously something on the cell phone or something they found on the cell phone that they want to show to the jury. And so in order to get that piece of evidence that was found on the cell phone, likely a video, they have to put the cell phone in and then somehow explain how they got the video. You heard maybe the public defender say that they're going to agree that the cell phone comes in because they've already had a motion about this. They've already had what we call an evidentiary hearing to determine whether the cell phone itself is coming in based on a proper or illegal search.
Gotcha. So this is, in all likelihood, Nikolas Cruz's cell phone that he used to take video of himself. This is something that we were talking about as an aggravating factor. He apparently took a video of himself just days before the shooting.
Well, I don't know whether this would be considered an aggravating factor. I think it goes to his cold, calculated, and premeditated manner aggravating factor. I'm sorry, I was thinking about the priors. You're right. Exactly. So what Mr. Satz is trying to do is show this is not just a mere moment of premeditation. I go grab my gun, I think about it, I shoot somebody. This is somebody that planned it, obviously, at least 3 days before. So we call that heightened premeditation, meaning that it is something more than a moment for reflection. All the law requires for first-degree murder, premeditation is a moment for reflection. He's going to show that this is heightened, meaning there's more than a moment.
And so it adds weight because in a case like this is not guilt or innocence, this is life or death. And so these jurors have to look at these aggravating factors and put weight to them. And this could be something weighty because it shows him describing himself in this video as a school shooter.
Well, if you don't plan the crime with somebody, you have to find a way that you're going to be able to prove that the crime was planned for a period of time. And so this is how the state is going to prove the planning, because of course he did this crime himself. So you can't say, well, he talked to me about it 3 days before, or he did something 3 days before. The reason why he bought the gun was because he was planning to do this. You have no evidence of that. What you do have evidence of, obviously, that they're trying to bring in is this planning, and that's why the defense is objecting hard, because they don't want that aggravator to be proven beyond a reasonable doubt.
And so they are probably talking about that now. Probably the judge will overrule it, and probably we'll see the video. This is video that's been out in the public, so I would imagine that not only would the jury see it, but we, the public, as well as those in the gallery, would see it as well.
So you're kind of wondering, sometimes the judge may call you sidebar and say, listen, are we going to have an agreement subject to your objection that we're going to do this, or is Mr. Satz going to have to call the person that downloaded the video to bring forward the chain of custody? The chain of custody doesn't always have to be put in if the lawyers agree.
Well, I would think that this was something that the state already thought about, bringing this witness in so late. It's already 10:52. The judge said she had somewhere to be at 11:30. She wanted to be done by 11 o'clock. So we'll see if this wraps up and if any objections get straightened out.
Yeah. But, what do they say, the best laid plans? He came in and said, I have only 5 witnesses today, and we can break early. And we're on witness 1.5, and we're about to go to lunch.
Right. So this is, a day that started off, with some very powerful testimony by this BSO sergeant looking at the video of the attack. And now we may be seeing some more video as well. Let's listen.
Exhibit 23D, like Delta for identification, will be received as states 429.
Okay, thank you, Your Honor. Detective Forsberg, when you went into the first floor hallway, were you familiar with the phone number 954-821-1007?
Yes.
And did you use your phone to call a number when you were walking through the hallway?
Yes, I did.
Okay, tell us exactly what you did.
I started on the west end of the first floor entrance. I started immediately. I was actually originally given 3 separate numbers to call that were potential numbers that we were looking for. The initial number I started calling, it would ring, but wasn't getting an answer. I called it multiple times as I walked through the hallway, got about midway, and I received an answer on that phone. It ended up being a person by the name of McCaskill, Charles McCaskill. I had a brief conversation with him about what, or if any, his connection was to Nikolas Cruz. He stated he was an acquaintance, that he had used his phone in the past to order an Uber. I let him know that another detective would be contacting him shortly. I moved to the next phone, which was the phone starting or ending in 1007.
954-821-1107?
Yes.
Okay.
So as I was about the midway point of the hallway, I started calling that phone, trying to see if I could hear it anywhere in the hallway. I heard it faintly. It sounded like it was coming from the east location of the hallway. I continued calling it multiple times, until I got to the east end of the hallway, and then I could hear that it sounded like it was coming from inside the stairwell location on the first floor on the east side.
East stairwell.
Yes.
Okay.
So once I called it again, that last time, I observed the phone. I could see it on the floor. I could see it was face up with the screen up. It was ringing, and I could see that my phone call was going to that phone.
Okay.
And at that time, we identified that phone.
Okay, and then you collected it, right?
Yes, we had crime scene detective Crespo photographed and documented it prior to collecting. It was placed in the evidence bag and sealed up for Detective Perez to take.
Okay, and you gave it to Detective Perez, correct?
Yes.
Okay, thank you. Your Honor, I have no further questions of Detective Forsberg.
Defense, any questions? Okay, thanks. You said no, Benjamin, right?
Yes,
Ms.
I
Ba- Ms. Benjamin?
Yes.
Thank you. Thank you, sir, you're excused.
Thank you.
Next witness.
Yes.
Detective Perez.
Okay, well, I wasn't sure if we would hear from another witness, but now we will. So this was this BSO sergeant who talked about finding the phone.
So sort of like I do when I can't find the phone, I go to another phone and call it, and that's exactly the good old-fashioned detective work that the detective did. He just started calling it and see where it rang, and he didn't have to use Find My Phone. He just called. So there you have it.
So there you have it. So that is the phone, and so this was the witness who sort of set up what the phone is, where it was found.
Exactly.
And so the thinking is that now we may
We're getting
learn
towards
about the contents of the phone.
Right. We're working towards it. And maybe, I think the judge said she's breaking at 11:15, so maybe she's really working at a clip. I give her credit. She doesn't waste any time, and she doesn't waste anybody's time. So that's really a credit to her.
And so this is another witness who's taking the stand, also a law enforcement officer.
I believe that Detective Forsberg said he gave it to Detective Perez. I heard them yell out Detective Perez would be next, so maybe he took the phone and sent it to the lab to get it downloaded.
Thank you, sir. Put your hand down and be seated, and when you're seated, please state your full name and spell your last name for the record.
Valerian Perez, P-E-R-E-Z.
And your occupation, sir?
I work for the Broward County Sheriff's Office.
Okay, and how long have you been with the Sheriff's Office?
Just shy of 30 years.
Okay, and what are you assigned to now?
Currently, I'm an administrative sergeant for the Dania Beach District.
Okay. I'd like to call your attention to February the 14th, 2018. You remember that date?
Yes, I do.
All right, did you have an occasion to respond to a certain location?
Yes, I did.
And where did you respond to?
I responded to Stoneman Douglas High School at 5901 Pine Island Road.
Okay, let me show you now State's Exhibit Mark 429 that has been introduced in evidence, and ask you, Detective Perez, if you could take a look at that and see if you can identify that.
Yes, I can.
Okay, and how did you first come in contact with that?
I first came in contact with this phone through Detective Forsberg. It was a phone that was discovered inside the school, and he brought it out to me.
Okay, and he gave it to you?
Correct.
And that's the phone he gave to you, correct?
That is correct.
And what did you do?
I took the phone to another detective in order for him to do some forensic work on it.
Okay, who did you give it to? What's the name of the detective?
Ronnie Faircloth.
Okay. Thank you very much, Detective Perez. Your Honor, I have no further questions of Detective Perez.
Do you have any questions? No, Your Honor. Thank you, sir. You're excused.
Thank you.
So it's sort of unfortunate that the Public Defender's Office isn't just going to agree, and not make the state go through these gyrations of calling everybody that sort of touched the phone. Because the phone is what the phone is. It's an individual phone. It's not a grain of sand where we can't tell what it is.
An early break. This is my fault. I have a meeting that I have to go to at 11:30. So it's 11 o'clock, just before 11 o'clock now. We'll be in recess until 12:45. Please do not discuss the case among yourselves. Please do not let anyone approach you or talk to you about the case. Please leave your notebooks behind. Please follow the same procedure that we've been following, and please be back at 12:45. Thank you so much.
So So you're right about the judge wanting to get this through and get this done at a pretty quick clip. Initially, she said 1:15. Now she wants everybody back by 12:45.
Right. What concerns me, and what would always concern me, is the jury going about by themselves this close to other people that know things about the case. I would prefer the judge have the bailiff get them their lunch, go into the jury room, let them be sort of secluded. They are out and about. It's very hard to keep them from hearing or overhearing things that are being said. So the fact that she's making lunch tight, maybe, you know, she's looking at the time period. I'm looking at, God, that gives them an awful lot of time to walk around the courthouse complex. It's hard to not listen.
Right. Right. And I guess that is the question. These jurors are sequestered technically, but they're not being told to stay in a room. They're not spending the night anywhere. So really, they are out and about, even.
They're on
their own
they're
time,
on
too.
the honesty behavior.
Sure.
That means that they're not sequestered. They have to sequester themselves, and you have to rely on them to do that. That is very difficult in today's society.
Sure.
You know.
Well, we were talking about this. Okay, you can't, look at the news. You can't talk about this to anybody. But I mean, all of us have phones, right? I mean, you have a phone. You wake up in the morning and you get news alerts, or somebody texts you. I mean, what if you can't control a friend texting, not knowing or not thinking, oh my gosh, did you see this news story that happened, or did you hear about this? And in this modern day and age, I mean, it's almost like you've got to be told to disable all your social media.
Right. But in order to get on this jury, you couldn't have been really a person that was a newsie. You know, you weren't somebody that was going to be knowing a lot about the news every day, because you would have known too much about the case, and therefore you would have been taken off. So these are people that pretty much use social media for other reasons.
Gotcha.
Yeah.
Well, so we heard from 3 witnesses by my count. Mike Satz said that he would get to 5 today. So the thinking is that when they come back from lunch, we've had those foundational witnesses setting up the telephone, the cell phone, which we believe was used to sort of shoot that inflammatory selfie video leading up to the actual shooting on February 14th.
I'm thinking they want to end today with that video. I'm thinking they don't want to end with the medical examiner. I'm thinking they want to leave this next break. It's a 4-day break. Or next week. Yeah, next week they're going to work. So how you end your case on the weekend is well thought.
Sure, because that's what these jurors are going to be thinking about until they get back into the courtroom.
You know, we like to say it's not a play, but it is. We do have a trial order, and we do like to call the witnesses in a particular order so that we end on a note that we want the jury to remember. The defense will do the same thing. They don't want to end on something that's negative for them. They want to end on a high note for them. And you'll see they'll make their choices in a similar manner.
Well, and as a prosecutor for 30-plus decades, you know the way this goes. So you've watched and you're watching this, and you know how it's played.
Yes, and your stomach doesn't feel any better on Friday afternoon until the verdict is read. And then it depends on how the verdict is read, whether your stomach continues to tumble or you sleep restfully.
Well, we have about an hour and 45 minutes of a break right now. We will come back. You're not going to miss a moment of it. Gail and I will be back at about 12:45, 1 o'clock, let's just say. She wants the jury to be back at 12:45. That usually means we'll start at about 1 o'clock. You're not going to miss a minute. We'll be back then. This is week 2 of the penalty phase of the trial of Nikolas Cruz, the confessed Parkland shooter. Hi, everybody. I'm Janine Stanwood, along with our legal expert, Gail Levine.
Good afternoon.
Longtime prosecutor. Thank you for being here.
Thank you for having me. This has been very, very rewarding in that I can get to talk to people about what's really going on in the courtroom. I'm really enjoying it. Thank you.
We are back now. Let's take a listen.
Then coming at 9, 30 minutes later, so we'll start at 9:30 because that seems to be more realistic. And then on the 4th, they're going to come at 8:15. That's Thursday. And then I put on the 8th, just to be absolutely sure, in case something were to happen and the state didn't finish their case next week, I put the 8th, which is Monday, to be determined, and then I, for the rest of the week, put jury off. Okay.
So we are waiting to hear who gets called next. A couple of housekeeping things. We heard before the break from some law enforcement officers who had the cell phone belonging to Nikolas Cruz. So the question is, will we see something from that cell phone?
Yes. Either it'll be right up after lunch or they'll save it for later. But I think that we're going to see some cell phone information today.
We know that Nikolas Cruz made some social media posts. There was also a question about some music that he was listening to in the Uber ride from the home where he was staying to Marjorie Stoneman Douglas that day on February 14th. So we're waiting to see what that is. Of course, remember, Gail, there are also some medical examiners who also need to testify.
Right.
Begin the afternoon session and the next witness.
State's ready.
Judge, if we may go sidebar, please. Sure.
The jury.
You said for the jury's not here yet.
Before we bring them.
Okay.
Now we're going to sidebar.
So the jury will be coming in. They'll be calling their next witness, witness number 63. By my count, there are just 2 more witnesses in the day because Sats had indicated there would be 5.
Mm-hmm.
So we've heard from 3 already. So once again, they're having that sidebar. They have their headsets on. Likely they're discussing the next witness?
Yes. There must be some objection for the next witness, which makes it seem like one of 2 witnesses, the medical examiner and the social media. They'll have objections, as they should, to preserve their record and to make sure things that don't go in front of the jury, that shouldn't go in front of the jury, don't go in the front of the jury.
Just sometimes, the defense doing their job.
Mm-hmm. And sometimes they say it and the prosecution says, we agree. And sometimes they'll have a long, drawn-out fight like we saw this morning.
Yes, this morning I think we thought that it would be a little bit quicker.
Oh, yeah.
There were a couple of issues, but now they are discussing whomever the next witness will be. We have heard from medical examiners who have performed the autopsy on 13 of the 17 victims. So the question is, will we hear from a medical examiner today who has performed autopsies on the rest? We will see what happens. These have been very deliberate, very gruesome in their descriptions, emotional for those family members who have chosen to be in the courtroom, but necessary for the state to prove their case and to say that Nikolas Cruz ought to die.
Right. They're not just proving the homicides, they are absolutely proving the manner in which the victims died. So the certain victims suffered at the hands of the defendant prior to dying. And that suffering we call heinous, atrocious, and cruel, meaning that the murder happened in a way that was different than somebody, for instance, getting shot in the head and immediately dying.
We definitely heard yesterday testimony from medical examiners who, for example, performed the autopsy on Gina Montalto. We learned, as we know from prior testimony, she was sitting outside class, she was on her laptop, and according to the medical examiner, there were contact wounds. Meaning what? Meaning the gun was close to her.
Within 2 inches. Within 2 inches. That is within 2 inches. So that is very significant, very deliberate, and as anybody would imagine, what the word we use is pitiless, meaning showed no pity.
tough for so many people to hear, but as you and I have discussed this, you know you've been a prosecutor for years. You know that the family members, it's their choice. They don't have to be there.
Absolutely.
And there are services that are provided to them to make them comfortable as they make that choice to sit into that
we
courtroom.
often hear people say, why do we have to do this? Why do the victims have to listen to this? Well, that's the system of justice that we have. We allow the defendant to confront his witnesses. And the family can be there. There's a constitutional right for them to be there. But they can choose not to exercise that and stay back and not listen to the parts that upset them. But again, most of them, I would say most, if not all, are on the prosecution team. They want to be there, and they have, it's sort of oddly, it becomes a bit of a family. These victims become your life.
And we have seen it in the gallery. We've seen members of different families holding hands. You can see the pain in one father's face reacting to the autopsy of another mother's child. And so you're absolutely right. When you're on a prosecution team, when you're on the state's team, how often are you in contact with these family members? So, for example, we saw family yesterday, for example, the Montaltos, listening, knowing that their daughter's autopsy will be read. So how does that work? Do they get a call the night before or that week?
Right. We're going to talk to them at the end of every trial date. We meet them back to our office. They probably, like I say, they have a room there for them. They'll talk about the day's events, how it went. They have questions sometimes. You have to answer their questions. And then we would say, listen, tomorrow, Mr. and Mrs. Montalvo, your child's autopsy, think about it overnight, decide what you want to do. I might even make a call later in the night, maybe 9 o'clock at night, say, how you doing? Have you made a decision? Do you need some help? Do you need some counseling? I have a counselor. They know the counselors. They talk to the counselors regularly. What can we do to make it comfortable? You don't want to be in there? Fine. Perfect. We'll let you know when the next witness comes.
Right. And many have said they want to be there. They want the public to listen to what happened to their loved one. And you talked about services. We've seen some shots from the courtroom where a lot of these family members look like they're using blankets and pillows just for comfort.
Yeah. And also, remember, these victims are not our clients. Our client, as the state attorney's office, is the state of Florida. But these people are people, and we try to remember that.
From July of 2017, are those all alleged to have been made by the defendant?
Yes.
So it sounds like she said July of 2017?
Correct.
Something that maybe the defendant, maybe Cruz, had recorded himself.
Yes,
You're
about 7
objecting-
months before.
Let's take the July of 2017 post first. You're only objecting to line 5.
Well, Judge, to be clear, we're objecting on all of the social media under 401 and 403.
Okay.
As well as renewing our objections from the search warrants that I placed on the record earlier today.
Okay.
The demotions. And that's because it's obvious that utilizing these social media posts is purely being used to inflame the jury. So that's our argument and that they're irrelevant. Specifically as to the comment that you have in front of you from State's Identification 23I.
Okay.
We're objecting because this is the state's attempt to invite the jury to consider victim impact evidence as an aggravator, which is impermissible. As to that comment.
And Your Honor?
Yes.
The state, to put this in context, Your Honor, this is coming in under cold, calculated, and premeditated. These comments go back to 2017. They show the planning, the thought processes of the defendant, his state of mind, what he was searching for on the internet. This all goes to CCP, and not just for the establishment of the aggravator, but as to the weight that it should be given by the jury. These searches are absolutely relevant. The fact that they are unpleasant, the state doesn't seek to introduce pleasant evidence. Yes, it is against the defendant, but this is what the defendant was searching for, and that's why the state seeks to admit it. It goes to CCP.
I thought these were comments.
They are.
You said searching for.
Their searches and their comments, they're what the defendant has put on the internet, Your Honor.
But the two things that I'm looking at are comments that I assume you made in reference to a YouTube video. It says YouTube comments.
Yes.
Judge, this is, what I'm handing you is the actual copies of all the evidence. I just gave you two examples, or Mr. Satz gave you one and I gave you one. This is where everything...
But the specific objections are to these two comments. On October 23rd, 2017, there's a YouTube comment that has 3 comments that were made. 2 on October 23rd and 1 on October 31st regarding a mass murder, hating people, and so on and so forth. You're only objecting to the second comment on that as to more specific grounds.
With more specific grounds, Judge, but just to reiterate, overall objecting based on 401 and 402.
I understand. And then on the comment, I guess the document summarizing YouTube comments made on July 3rd, 4th, and 5th of 2017, you only have a more specific objection to the comment made July 4th, 2017 at 12:38:14 a.m. Universal time.
I'm not sure.
I don't know what that means either. But about the families.
Yes, Judge.
Other than that, it's a general objection.
Under 401 and 403, yes, Your Honor. So
So-
all the social media.
Okay, so the documents that Mr. Marcus is talking about, you have a general objection, not a specific objection.
Yes.
And I don't mean to downplay your objection, I'm just trying to make sure I understand the difference.
No, I understand, Your Honor.
These are the defendant's thoughts, Your Honor. This shows the state of mind. These are from what I'm looking at on October 23rd, 2017, the comments that the defense is objecting to.
Right.
October 23rd, 2017, this is shortly in temporal proximity to when the murders took place. This clearly shows what he's thinking about, what he wants to do, and what he actually did. And these are his comments. And it goes to CCP, the aggravator, and it goes to the weight that these jurors can give. And they follow each other in sequence. I mean, I understand that the defense doesn't want these comments read in open court, and I will respect that as long as the court can follow along and see the sequential order of the comments.
I can.
And Judge, as to the October 23rd, 2017 comment that was posted at 11:26:09 p.m., the specific issue is the first part of the sentence.
Okay.
Right? So our request is to redact that first part. I don't think it takes anything out of context in regards to the aggravator that Ms. McCann has placed on the record.
The defendant has already pleaded guilty to 17 counts of murder, Your Honor. So I don't think taking anything out is going to change anything. It's certainly not going to lessen any prejudice. As I stated before, Your Honor, the state in these proceedings is only going to introduce prejudicial evidence against the defendant. It is our job to present aggravating factors. It's the defendant's job to present mitigating circumstances. We wouldn't be introducing this unless it was relevant to our job to present aggravation.
The problem with the first part of that comment, Your Honor, again, is that it is anticipatory rebuttal. It doesn't particularly go to CCP. I can see the state's and respect the state's argument on the second half of that.
I mean, how would it be any different if I were to say, no one's ever hurt me, but I like to hurt people?
I would argue that that would be anticipatory rebuttal if the state was to bring the first part of that comment.
But wouldn't it be just me explaining that there's no reason for what I want to do, I just want to do it?
Respectfully, I disagree. I think that using those first 4 words and allowing them to be introduced is the state's way of trying to get rebuttal in when it's inappropriate.
So you're suggesting that it may not be admissible in the state's case in chief, but it might be admissible depending on what you put on your case as rebuttal evidence?
And stating possibly that those particular words may be some, without getting into what our case is, Judge.
Okay.
It may be relevant rebuttal at that point, but it is not appropriate at this point.
Okay, state, here's your exhibit back in your, I think this is just a copy of an exhibit, and I'm going to wait to hear the context and the relevance, and I will go with them. But you can, note your objection, renew your objection, and then I'll decide.
Okay, and that goes for also the other comment from July 2017, where the argument I made regarding inviting the jury to use victim impact evidence as an aggravating factor.
Yes, I'm going to rule at the time as to both of them.
Okay.
Give me just 1 second.
Thank you.
Thank you.
So at issue here are some online comments from July of 2017. The state says, hey, this shows that he was cold, calculated, premeditated. It adds weight. It's important to our case. And the defense is saying, not so fast.
Right. The defense is saying this doesn't become relevant until we show something about his character. And his character so far from us hasn't been brought in. So we want you to wait, but the problem with that is if they don't touch upon these type of statements, then the state would be prevented from later bringing that in. Because rebuttal is true rebuttal. It must rebut something that the defense has put into evidence. So what they're trying to do is say, listen, right now it's not relevant. It may be relevant after we're done. And what the state's saying is, no, it's relevant now because it goes to his aggravator, cold, calculated, and premeditated. We are not putting it in as a rebuttal to mitigation. So one's trying to say it goes for one part of the case and one's trying to say it goes for another part of the case.
Right.
What they keep referring to, so that you know when they say 401, 403, those are rules of evidence that say if something is more prejudicial than not, then it doesn't come in. And the state's argument always is, everything we put in is prejudicial.
Right.
So even if you don't like it, it's prejudicial.
Right. I think the thinking, this is what the state was saying, was that, this is unpleasant. And that's,
exactly.
that's what we're doing. We're showing what's unpleasant about it.
Right. In fact, Ms. McCann's words were, it is unpleasant. I wrote that down. So I know that they are fighting very hard to get this in. I think this is something that's been brewing for quite a while that the judge hasn't made a ruling on. She's been kind of thinking about it, trying to see where she is. She's off the bench now. She might have some law clerks back there that are pulling some research for her. As you see, the public defender team changed their chairs.
Right.
Mr. Wheeler sitting behind, allowing this particular public defender, whose name escapes me, doing all the arguments, so she's closest to the judge and she can be heard.
Because that's her area of specialty with this case.
She must have spent a lot of time researching this, and she looks very prepared.
All right, let's listen to what the judge has to say.
Dr. Malik is going to be first. Right?
Okay,
He
so
came in
next.
from out of town, so we want
Okay, no problem. Sure, I can be the one person. Sometimes I don't know who to look to for the objection, and that's fine. I can figure it out.
Bring the jurors in, Judge.
So what does this mean?
Well, there's some talk about a witness named Dr. Malik. Dr. Malik is a noted defense expert that testifies about people's growing up and how they behave and how that becomes who they are. If Dr. Malik looked at these statements, then of course they would be eligible for cross-examination to be brought in with Dr. Malik.
And he would be a witness for the defense.
Yeah, she's a she.
Right. She. Excuse me, Dr. Malik.
Sorry.
Absolutely.
Yeah, if they don't call Dr. Malik, then the state would be prevented. So now what I think the judge is going to do is wait for the questioning and make a on-time ruling. So I don't think anybody knows which way she's ruling right now.
There have been questions about what can be admitted, certain things that Nikolas Cruz has said online, certain symbols that he's drawn on magazines of his guns that we have not, at least the open court has not heard about yet. So they're standing up. The jury is likely walking in.
Yes.
And the state will call its next witness.
And everybody's on their toes. What's the judge going to do?
Okay, the jurors are present. State, you may call your next witness.
Thank you, Dr. Craig Malik.
This is Dr. Malik. I believe this may be a different Malik with the same last name.
Well, you know a lot of people, so
the names are interchangeable sometimes. I apologize.
Well. All right, so this is then likely a medical examiner, maybe a medical examiner who has performed an autopsy on one or more victims.
Which I think is interesting that they're now medical examiner, witness, something else, putting it in so each victim, their medical examiner information becomes just theirs, and it doesn't become just a whole sea of medical examiner. The way they're doing this is very nice.
And as you mentioned, I think you have to break it up. I mean, not only is it sort of excruciating for people to hear, but then it becomes monotonous.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
Yes, my name is Craig Thomas Malik, M-A-L-L-A-K.
Good afternoon, Dr. Malik.
Good afternoon, Mr. Satz.
And what is your occupation, sir?
I'm a forensic pathologist.
Okay. Could you briefly give us a history of your education, sir?
Yes, sir. I attended Michigan State University and received a degree in forensic sciences working in a crime lab. From there, I went to Creighton University in Omaha, Nebraska, and I got both my JD, my law degree, and my medical degree. The Navy put me through medical school, so I went right off to active duty after medical school. After the first year of residency, I was sent out with the Marines for a year as a general medical officer. They call you a regimental surgeon, but you're basically just a general medical officer. And then after that, went back and finished my residency both in Oakland and then at Bethesda at the National Naval Medical Center. From there, I was sent to the Armed Forces Institute of Pathology, which is on the grounds of the old Walter Reed, which is now closed, and specialized in forensic pathology. And I'm board certified in anatomic and clinical hospital pathology and in forensic pathology.
Okay. And you were in the Navy at the time?
Yes.
Okay. And then what happened with your career with the Navy?
After I finished my fellowship, I was sent to Okinawa, Japan to be the Armed Forces Medical Examiner for the Far East, and I served in various other capacities there. From there, I was sent to Millington, Tennessee, which is right outside Memphis, where Naval Personnel Command is, to do an administrative tour as a detail. And I wrote the orders and sent people all over the world. And I was about to get out and come down to Florida, actually, and then 9/11 happened, and I was called and asked if I wanted to be the Chief Armed Forces Medical Examiner. And in that role, not only the military, but there are no other forensic pathologists at the federal level, so we worked for all federal agencies. And right after I got there, the Space Shuttle Columbia crashed, and I was in charge of the medical investigation of that. And then the wars in Iraq and Afghanistan broke out, and we worked very, very hard. And one of the things that I really am the most proud of is there are no MIAs or POWs from either of those conflicts. Everybody has been accounted for. And so there's no family that doesn't know. And as the war wound down, I started to go out and interviewed for a civilian job. And I came down here thinking this is just a practice interview. And the next thing I know, they're calling me and asking me if I want to be the chief medical examiner here in 2012. And I stayed here for 9 years. We were very busy with the opioid epidemic, FLACA, if you remember FLACA, COVID, we had the airport incident where 5 people were shot, the nursing home, the overheating issue there following the hurricane, and of course this tragedy here.
Okay. With reference to, just briefly, how many autopsies in your career, Dr. Malik, have you performed?
It's in the thousands.
Okay. And how many of those autopsies were the result of gunshot wounds?
Well, especially in the military during 2 wars, there were lots of gunshot wounds, okay. So hundreds and hundreds of gunshot wounds.
Okay. And you're familiar then with small arms gunshot wounds and rifle AR-15 type wounds?
Well, definitely.
Okay. And have you testified as an expert in forensic pathology in a court of record?
Yes.
How many times?
Probably been well more than 1,000 times in courts, state courts, international tribunals, federal level, throughout the judicial system around the world.
Okay. Dr. Malik, more specifically, I'd like to take you to Thursday, February the 15th, 2018. Did you have an occasion to perform an autopsy on one Carol Logren? Yes. Okay. I want to first show you State's Exhibit 109 is that Carol Logren?
Yes, sir.
Okay. And showing you State's exhibits for identification, Dr. Malik, 22S, 22R, 22Q, 22P, 22O, 22N, and 22M. Dr. Malik, would you be good enough to take a look at these exhibits and see if we can identify them for me, please, sir?
Yes, sir.
Where are they?
These are photographs that were taken during my examination.
Of Carol Logren?
Of Carol.
On Thursday, February 15, 2018.
Yes, sir.
And Dr. Malik, would these exhibits help you in illustrating to the court and to the jury the nature of her wounds?
Yes.
And would those photographs, those exhibits, assist you in explaining to the court and to the jury the manner and cause of death of Carol Logren?
Yes, sir.
Okay, thank you, Dr. Malik. Your Honor, I'd like to offer these exhibits, please. Casey, I've seen them, thank you.
Okay, is there any objection from the defense?
This one, we object pursuant to DMIL 12, and just incorporate all arguments and authorities therein. Thank you.
Thank you. Over the defense objection, states 22M, like Mary, will be received as 430. 22N, like Nancy, 431. 22O, 432. 22P, 433. 22Q, 434. 22R, 435. And 22S, like Sam, 436.
Dr. Malik, I want to show you State's Exhibit marked 430. Can you see that okay?
Yes, sir.
Okay. Could you explain, you have that one wound marked A. Could you explain what that is and what your findings were, sir?
This is an entrance wound from a gunshot.
Okay. And what damage did that cause?
That bullet pathway went across to the right side of the chest and caused injury to the vena cava, which is the large artery that brings blood back to the heart, and then portions of it were found in the right breast tissue.
Okay. Now I'm going to show you State's Exhibit marked B, and B appears to be right next to where you had the arrow for A, correct?
Yes.
And how about this? What is that?
That is another entrance wound from a gunshot.
And the path and damage of that bullet, sir?
That followed the same pathway as gunshot wound A.
Okay. And State's Exhibit marked 432, and you have a gunshot wound appears to the back labeled D?
Yes.
Okay. Could you tell us about that wound?
Yes, that's a third entrance wound that entered the side of the chest.
And damage?
Damage to the chest wall, and then severe damage to the heart.
Okay. Of those three wounds, Dr. Malik, A, B, and D, would any of them any of the three in and of themselves cause fatal injury?
Oh, definitely D.
D, definitely D. And A and B?
Potentially salvageable.
Okay. And showing you State's Exhibit 433.
This is what a term that we came up with in the military called the ballistic impact point. As these bullets hit the floor and walls, they fragment and they lose a lot of their energy, and they will just hit the skin and maybe go a little ways under the skin and then stop. This wound here does not continue beyond where you see it.
Okay. And State's Exhibit 434.
This one looks like a gunshot wound again, but it's a ballistic impact point. Again, there's nothing underneath the skin. There's no pathway. It stopped right there.
Okay. And as a result of your autopsy, Dr. Malik, were you able to determine the cause of death of Kara Logren?
Yes, sir.
And what was the cause of death?
Multiple gunshot wounds.
Okay. And showing you State's Exhibit 435. What does that show?
These are some of the fragments that were recovered from the pathway. As you can imagine, they're all basically in the same area, so it's difficult to say which bullet these came from.
Okay. And State's Exhibit 436.
And again, this shows 2 copper jackets, and a third piece of copper jacket, and then 2 internal parts of the bullet, the lead from the internal from the bullet.
And Doctor, in your experience, you've seen handgun wounds and AR-15 type wounds, correct?
You know, it's high velocity versus low velocity.
Yeah. What's the difference?
Well, on a handgun, they usually travel around 1,200 feet per second. The bullet does. They vary a little bit, but with these types of this type of munition, it's a very small bullet. It's a .22 caliber bullet, but it's moving at over 3,000 feet per second. And so as it enters the body, it causes this temporary cavity around it, but there's so much energy with these bullets. And so it just tears skin, bone, organs for 20 to 30 times bigger than the diameter of the actual bullet as it imparts its energy as it goes through the body.
And Doctor, were you able to form an opinion with reference to wounds A, B, and D on Kara Logren? Were you able to form an opinion as to the order of shots hitting her body?
Now, it's difficult to tell, but the 2 on the top of her shoulder, there was a lot of hemorrhage with them. Once the wound from the back left side of her body severely injured the heart. Now you're opening up the system, the blood pressure is going to drop right away, and you're not going to see that much hemorrhage around it. So the D entrance wound is probably sometime after the first 2.
Okay. And that D was the wound to the back?
Yes.
Okay. Thank you, Dr. Malik. I have no further questions, Your Honor.
Defense, any questions?
No, ma'am.
Okay, thank you, sir.
Thank you, Your Honor.
So more brutal testimony from a medical examiner talking about just the power of the weapon that was used against this particular victim, Kara Logren.
Right. So Dr. Malik, obviously a man and obviously well-credentialed. What he was really describing, and I think where Mr. Satz loses out a little bit, is that he actually could have had the medical examiner show on his body 2 shots to the shoulder. As she's turning, she's getting shot in the back. So she's moving.
Which means she knows what's happening.
Yes, she's seeing him and she's trying to run away. That's why she gets the 2 shots in the shoulder to the right side in rapid succession. And then the third shot is, he says, a bit later, which is basically because she's turning. And then he talks about the ricochet, the fragments of bullets that are hitting upward to her. And what he described very, very well was that these bullets are like a drill. And when they go through the body, unlike a handgun that just travel through the body and do damage, these actually drill all of the bone and the cartilage and all of the soft tissue as it goes through at the rapid succession that it does.
And keep in mind, for those of you who are watching, we're not seeing any of these photographs. The judge has already determined that the public won't see most autopsy photos because they're too gruesome, but the jury is seeing all of that.
Yes.
The jury is seeing these autopsy photos, which go to, describing which go with the testimony of the medical examiner and his description of just how brutal this shooting was.
Yes. I don't know whether they showed the insides of the heart blowing up, but basically her heart blows up.
Affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
My name is Detective Nikolas Masters, M-A-S-T-E-R-S.
Good afternoon, Detective Masters.
Good afternoon.
What is your occupation?
I'm a detective with the Broward County Sheriff's Office.
All right. How long have you been with the Broward County Sheriff's Office?
I've been with the Broward Sheriff's Office for almost 19 years.
Okay. And what is your present assignment?
I'm currently assigned to the Strategic Investigations Division and the Internet Crimes Against Children Unit.
Okay. And I'd like to call your attention back to February of 2018. What was your assignment at that point?
The same. I was assigned to the Internet Crimes Against Children Unit.
Okay. And what are your duties and responsibilities?
So as a detective assigned to that unit, I investigate child pornography cases, but I also assist other units as well as other agencies in the analysis of electronic data.
Okay. So that's what you do, forensic data analysis?
Yes, electronic data analysis.
Okay. And how long have you been doing that?
Currently around about 9 years.
Okay. And please tell us what training and education you have had to be involved in electronic data analysis.
I went through the basic police academy. I've also attended numerous forensic courses, Cellbrite, certified operator, and physical analysis. For cell phone analysis, the extraction and analysis of data from vehicle infotainment systems out of vehicles, numerous other forensic classes involving the preservation and collection of digital data.
Okay. And have you ever testified as an expert in forensic data analysis, electronic data analysis in a court of record?
In electronic data, yes, I've testified in 10 federal cases.
Okay. I'd like to call your attention to this case. Specifically, February the 14th, 2018. Did you become involved in this case against Nikolas Cruz?
Yes, I did.
Okay. And when did you get involved in it?
Shortly after we were made aware of the incident, around 2:45 to 3 o'clock.
Okay. And as a result of your investigation and based on your experience in the position you had with the Broward Sheriff's Office, did you evaluate any social media analysis?
Yes, we were receiving different social media accounts through the analyst teams at the Strategic Investigations Division, and then we were also monitoring intel that was coming in over the radio.
Okay. So let me now show you State's Exhibit marked 23N.
And Detective Masters, tell me what that is.
These are the YouTube comments, or some of the YouTube comments from the Nicholas Jacob Cruz at gmail.com account.
Okay. And there are some certain comments. How did you find those comments?
I conducted searches looking for various keywords and topics related to mass shootings and other types of violence.
Okay. And you received what from whom to review it?
So these were records that were provided by Google.
Okay.
And that's what the attached documents are their record certifications, which was linked. This account was linked through the YouTube records through the Uber records that we obtained.
Okay. And were there many items that you went through to pick out these particular items?
Yes.
Okay. Was it come in a disc?
They give us a download through their law enforcement portal.
Okay. And you reviewed the download and you picked out certain comments, correct?
Yes, I did.
Okay. And attached to that is a certificate from Google?
Yes, sir.
For what?
They're just authenticating that these are records that they keep in their general business, and then giving a list of the files that they provided.
Your Honor, at this time, I'd like to offer State's Exhibit 23N.
is there any objection to the admission of State's Exhibit 23N, like Nancy, for identification?
Yes, Judge, I'd like to review my earlier objections, specifically from arguments made in D-175, D-213, D-MIL-10.
Okay, your objection is noted. Over the defense objection, 23N, like Nancy, will be received as State's 437.
Okay, so these are YouTube comments. The defense said we don't want them.
Detective Masters,
State
now
says
I'm going to show you
yes,
State's
and the
Exhibit
judge sided with the state.
Yes.
437.
So are we going to hear some of the things that he said on
You testified
Well,
there are
online?
YouTube comments, right?
One would hope the judge would allow it to be stated out loud, but she has been
I can't see it yet.
she's been very closed about this.
Can you see it now?
Yes, sir.
Okay. You want me to make it bigger?
No, I can read those.
Let's see. Oops. Okay. So these are the comments you got from Google for YouTube comments, right?
Yes, sir.
So it lists the creation date. That means the date the comments were made.
Yes, it does.
And then it lists the comment, okay?
Yes, sir.
So could you go and, read the dates and the comments for us?
Yes, August 30th, 2017, at 5:29 and 15 seconds p.m. UTC, which is Universal Coordinated Time. I plan on shooting them soon, year 2020, date of massacre unknown, location unknown somewhere in Florida.
Okay.
The next one is September 2, 2017, 6:56 and 39 seconds p.m. UTC. Just want to kill people. September 8th, 2017, 1:51 and 14 seconds p.m. UTC. I rather kill people, 2020. September 16, 2017, 3:53:25 a.m. UTC. The amount of time it took for the police to come, I think this is fake. September 18, 2017, 12:25, 26 seconds a.m. UTC. I hide it deep within and think about killing people. September 18, 2017, at 12:42 and 43 seconds a.m. UTC. The last part makes me scared what happens when I have no one. I am 18, still in high school, and everyone is on their way to college while I am there thinking about killing people and ending their lives. I hate my life, and I want to take people with me. September 22, 2017, at 4:21:45 seconds a.m. UTC. I fucking hate humans. September 24th, 2017, 11:49 and 1 second p.m. UTC. I'm going to be a professional school shooter. September 28, 2017, 5:22 and 41 seconds p.m. UTC. My life sucks. I failed high school. I'm going to go on a killing rampage. October 10th, 2017, 5:37 and 14 seconds a.m. UTC. I'm going to kill a lot of fucking people. I hate you all after what happened in Las Vegas. I had enough. October 10th, 2017, at 6:36 and 54 seconds a.m. UTC. I have no problem shooting a girl in the chest. October 13, 2017, 2:13 and 38 seconds a.m. UTC. I hate everyone and everything. I fucking go into a bad part of town and make a sniper nest and kill people. Just don't give a fuck about life. January 17, 2018, at 4:37 and 20 seconds a.m. UTC. I hate people. January 17, 2018, at 5:52 and 33 seconds p.m. UTC. I want to kill shit ton of people and murder children. January 17, 2018, at 6:12 and 30 seconds p.m. UTC, I want to kill people. January 30th, 2018, at 4:38 and 48 seconds a.m. UTC, I hate people.
Okay. That was YouTube comments. And now I'm going to show you. State's Exhibit marked 23M.
Detective Masters, and if you could take a look at this, please, and tell me what that is.
This is the search history events from the Nikolas Jacob Cruz at gmail.com email account.
Okay, and what's it a search?
So whenever you are logged into a Google account and you are using something such as Google as your search engine, they log each and every search that you use, or even if you use anything on the Chrome browser, they keep track of all of that and tie it back to your account.
Okay. And is there an authenticity from Google?
Yes, there is.
Your Honor, at this time, I'd like to offer State's Exhibit 23M.
Defense, is there any additional objection?
No,
To
Judge,
23M, like Mary?
just wanted to renew our objection previously made.
Okay, so noted. Over the defense objection states 23M, like Mary, for identification will be received as 438.
Okay, Detective Masters, now I'm going to show you State's Exhibit 438. And searches. You able to read that okay?
Yes, I can.
Okay. And there are your initials at the bottom?
Yes, they are.
Okay. All right, so explain what this is.
So this is how the Google searches are provided as far as the text. We've formatted them out of the text document that they provide to make it more organized. But the first part shows a date and time stamp, again in UTC time, and then it shows the searched for, so that's what was actually searched for. Anything after the word for is what was actually typed into the search engine or the browser. And then below it shows how Google actually displays that link in your web browser URL bar.
Okay. So would you be good enough to read them for us?
Yes, sir. So it's August 24th, 2017 at 19:56 and 24 seconds UTC. Search for Charlottesville shooting. On August 30th, 2017 at 12:50 and 10 seconds UTC, he searched for the Polytech massacre. On August 30th, 2017 at 13:09 and 40 seconds UTC, searched for Columbine High School massacre. On August 30th, 2017 at 13:27:54 UTC, searched for Virginia Tech massacre. On September 2nd, 2017 at 18:12 and 9 seconds UTC, he searched for 5.56 ammo. On September 2nd, 2017, at 18:12 and 27 seconds UTC, he searched for 5.56 ammo for sale 1,000 rounds. On September 2nd, 2017, at 20, 26, and 23 seconds UTC, he searched for Smith & Wesson M&P 15 Sport with 2 handguards. On September 2nd, 2017, at 20, 27, and 37 seconds UTC, he searched for M&P 15 Sport handguard length. On September 14th, 2017, at 0000 hours, 4 minutes, and 24 seconds UTC, search for Virginia Tech massacre. September 14th, 2017, at 0007 minutes and 19 seconds UTC, he searched for Poly Tech massacre. On September 18th, 2017, at 03:13 and 38 seconds UTC, searched for 1,000 rounds 5.56. On September 18th, 2017, at 20:01 and 1 second UTC, search for 5.56 tracer rounds.
Okay, and here's the second page.
On October 3rd, 2017, at 22:55 and 21 seconds UTC, search for how many rounds were fired during the Las Vegas massacre. October 6, 2017, at 00:54 minutes, 49 seconds UTC, search for AR-15 mags. On October 10, 2017, at 1:42 and 10 seconds UTC, search for Aurora shooting victims. October 10, 2017, at 1:43 and 4 seconds UTC, search for Aurora shooting victims list. On October 10, 2017, at 1:43 and 37 seconds UTC, search for Aurora shooting how many rounds. October 10, 2017, at 1:44 and 24 seconds, search for Aurora shooting how many rounds were fired. October 10, 2017, at 2:42 and 43 seconds UTC, search for Aurora massacre.
Okay. Okay, Detective Masters, now I'm going to show you State's Exhibit Mark 23L for identification. Ask if you can identify what that is.
This is the YouTube search events, also provided by Google and the Nikolas Jacob Cruz at gmail.com account, along with the record certification.
Okay, and you compiled that, correct?
Yes, I did.
Your Honor, at this time I'd like to offer State's Exhibit 23L.
Wow. So we just saw some screenshots of his search history, of the comments that he made, comments about wanting to be a school shooter, comments feeling sorry for himself and how he wants to kill people. And then we saw his searches online.
Objection to the court receiving what's been marked for identification as State's
And now this,
composite Exhibit L.
this is his YouTube search history.
Right. And I think if you look at them one side by side, you'll see there's a lot of thought process prior to September 18th, looking up things, showing that he's smart enough to look up Polytech shooting. all these shootings, Las Vegas shooting, and then on September 18th, he makes a decision. You can see from his comments on YouTube that he makes a decision, and from then on, and then the stark statement, "I have no problem shooting a girl in the chest," which brings us back to Dr. Malik just a few moments ago.
Talking about Carol Logren and how she was shot in the chest.
This is definitely a person that's showing a mature mind and executive functioning. What can he do to make decisions? He's making lots of decisions daily, and the decisions are getting, the main decision, being a school shooter, is getting stronger and stronger.
All right, so the judge is right now cataloging these YouTube searches,
Yes.
and if what happens just a second ago, we're going to hear what those searches were.
Right. So we started out by seeing some comments that he made on YouTube, then some comments, some searches that he did on Google searches. All of this was done through search warrants. This isn't that we just call Google and we ask them to send it to us. They have to have probable cause for this. They did. They did it in a legal manner. It's not something that we do with just anybody. We don't just grab stuff. They did it legally, and now you're going to hear YouTube searches, which is different than what he commented on, obviously. It's more akin to what he Googled.
Pretty chilling stuff. I hide it deep within and think about killing people was one of his comments.
That is, and a little bit of some sadness. I failed high school. I'm a loser. And instead of him going one way, he went the other. He blamed other people for his problems and took them out on these poor innocent victims.
How many pages are there? Detective Master is now showing you State's Exhibit 439, consisting of 18 pages. Tell us what this is.
So these are the YouTube search events. So similar to when you conduct a search, either using the Google search engine or the Chrome browser, whenever you type in a search utilizing YouTube, so whether it's on their website or using the application on a mobile device, they also maintain those records and track what you're searching.
Okay. You want to read those for us, please?
Yes. June 15th, 2017 at 19:48 and 10 seconds UTC, search for McDonald's mass shooting. August 8th, 2017 at 5:57 and 11 seconds UTC, searched for Pumped Up Kicks, Columbine High School. August 9th, 2017 at 20:17 and 17 seconds UTC, searched for How to Become Evil in Society. August 10th, 2017 at 1:58 and 9 seconds UTC, searched for Pumped Up Kicks, Columbine High School. August 19th, 2017 at 20:15-21 UTC, searched for Park Shooting. August 25th, 2017 at 17:08 and 36 seconds UTC, searched for Charlottesville Shooting. August 28th, 2017 at 17:26 and 52 seconds UTC, searched for How to Shoot at 500 yards. August 31st, 2017 at 19:51 and 45 seconds UTC, searched for Polytech Massacre.
Okay. And page 2 of that exhibit?
August 31st, 2017 at 21:42:49 UTC, searched for Wanting to Kill People. September 1st, 2017 at 9:09:25 UTC, searched for School Massacre Kids with Guns. September 1st, 2017 at 17:47:07 UTC, searched for Columbine Massacre Song. September 6th, 2017 at 0:28:37 seconds UTC, searched for Massacre in Hotel. September 6th, 2017 at 29 and 9 seconds UTC, searched for massacre. September 6, 2017, at 0:29:45, searched for Russian massacre short film. September 8, 2017, at 17:14:15 UTC, searched for killing people. September 11th, 2017, at 1:16 UTC, searched for AR-15 shooting.
And page 3.
September 14th, 2017, at 0:39:57 UTC, search for Polytech massacre. September 14th, 2017, at 0:40 and 7 seconds UTC, search for Polytech massacre full movie. September 16th, 2017, at 3:47:48 UTC, search for Virginia Tech massacre. September 16th, 2017, at 15:18:35 UTC, searched for LA killing rampage. September 16th, 2017, at 17:19:45 UTC, searched for mass murderers. September 16th, 2017, at 17:20:33 UTC, searched for the Virgin Killer. September 16th, 2017, at 17:20:54 UTC, searched for Elliot Rodger. September 18th, 2017, at 0:26:20 UTC, searched for Pumped Up Kicks Columbine High School.
Do you know who Elliot Rodger is?
Yes, he's a mass shooter who is also known as the Virgin Killer.
Okay. Page 4.
September 18th, 2017, at 0:45:28 UTC, he's searched for Virginia Tech massacre. September 18th, 2017, at 2:44:35 UTC, searched for shooting people. September 18th, 2017, 3:23:53 UTC, searched for 1,000 rounds 5.56. September 26, 2017, 10:01:59 UTC, searched for Pumped Up Kicks Columbine High School. September 27, 2017, at 9:50:16 UTC, searched for Pumped Up Kicks Columbine High School. September 27, 2017, at 17:13:14 UTC, searched for AR-15 tactical shooting. September 28, 2017, at 3:48:16 UTC, searched for Polytech massacre pump up kicks.
Page 5.
September 29, 2017, at 0:56:14 UTC, searched for Polytech massacre full video. October 3rd, 2017, at 4:02:59 UTC, searched for the gun that was used in the Las Vegas massacre. October 4th, 2017, at 1:41:17 UTC, searched for 100-round drum AR-15. October 4th, 2017, at 14:12:49 UTC, searched for AR-15 shooting. October 5th, 2017, at 8:59:42 UTC, searched for left-handed AR-15. October 5th, 2017, at 16:55:19 UTC, searched for 40-round AR mag. October 6th, 2017, at 17:45:40 UTC, searched for 10-round mag. October 6, 2017, at 17:46 UTC, searched for 10-round AR-15 mag.
And page 6.
October 6, 2017, 18:39:06 UTC, searched for PMG 10-round AR-15 shooting. October 6, 2017, at 18:45:44, searched for AR-15 10-round mag shooting. October 8, 2017, at 23:41:12 UTC, searched for Pumped Up Kicks, Columbine High School. October 13, 2017, at 20:55:54 UTC, searched for AR-15 tracer ammo. October 16, 2017, at 20:40:37 UTC, searched for shootout with cops. October 16, 2017, at 20:49:22 UTC, searched for criminal shootout with cops. October 16, 2017, at 21:12:30 UTC, searched for AR-15 shootout. October 16, 2017, at 23:30:16 UTC, searched for Polytech Massacre full movie.
And page 7.
October 16, 2017, at 23:30:57 UTC, searched for Polytech Massacre pump-up kicks. October 19, 2017, 17:12:15 UTC, searched for school shooting. October 20th, 2017, 6:15:53 UTC, searched for top 10 murders caught on camera. October 20th, 2017, 6:16:30 UTC, searched for top 10 murders caught on tape. December 11th, 2017, at 21:09:59, searched for shooting at girls. December 11th, 2017, at 21:16:26, searched for shooting at women. December 12th, 2017, at 17:03:08, searched for Russian massacre short film. January 13th, 2018, at 5:57:28 UTC, searched for Virginia Tech massacre.
Okay. And page 8.
January 13th, 2018, at 5:58:09 UTC, searched for Virginia Tech massacre documentary. January 13, 2018, at 6:16:43 UTC, searched for being shot with AR-15. January 13, 2018, at 6:17:54 UTC, searched for shot with AR-15. January 13, 2018, at 16:24:45 UTC, searched for shooting people. January 14, 2018, at 5:07:37 UTC, searched for kill people. January 15, 2018, at 17:50:37 UTC, searched for AK-47 massacre. January 16, 2018, at 5:17:37 UTC, searched for how massacre works. January 16, 2018, at 5:18:07 UTC, searched for Las Vegas shooting. January 16, 2018, at 19:37:30 UTC, searched for school shooting song.
Okay. Page 9.
January 16, 2018, 19:42:30 UTC, searched for Columbine pump-up kicks. January 17, 2018, at 0:34 UTC, searched for perfect murder weapon. January 18, 2018, 4:51:19 UTC, searched for killing people. January 18, 2018, at 6:12:53 UTC, searched for school shooter. January 19, 2018, at 4:23:39 UTC, searched for why I want to kill women. January 19, 2018, at 18:19:15 UTC, searched for best places for a massacre. January 19, 2018, 18:20:13 UTC, searched for Smith & Wesson M&P 15 Sport 2 meltdown. January 20th, 2018, 17:58:24 UTC, searched for massacre.
And page 10.
January 20th, 2018, 17:59:50 UTC, searched for Las Vegas shooting. January 22nd, 2018, at 1:07:10 UTC, searched for killing people. January 22nd, 2018, at 1:20:20 UTC, searched for massacre. January 22nd, 2018, 2:09:03 UTC, searched for murder. January 24th, 2018, 17:47:25 UTC, searched for killing people. January 24th, 2018, 17:58:31 UTC, searched for shooting people. January 27th, 2018, 17:43:58 UTC, searched for Virginia Tech massacre. January 28th, 2018, at 13:08:24 UTC, searched for Eric and Dylan. January 28th, 2018, 13:08:35 UTC, searched for Eric and Dylan documentary.
And Detective Masters, you know who Eric and Dylan are?
Yes, sir, they are the shooters from the Columbine massacre.
Page 11.
January 28th, 2018, 14:54:51 UTC, searched for school shooting video. January 30th, 2018, 4:39:51 UTC, searched for school shooting fail. February 2nd, 2018, 14:45:51, search for mall massacre lesson. February 2nd, 2018, 14:35:38 UTC, search for mall massacre active self-defense. February 7th, 2018, 13:21:40 UTC, search for guitar case. February 13th, 2018, 17:14:10, search for school shooters.
Detective Masters, now I want to show you State's Exhibit marked 23K for identification. Yes, you can identify this.
These are some of the search history events from the Linda Cruz 1949 at gmail.com account.
Okay, and how's that related to the Nikolas Cruz account?
So when the Broward Sheriff's Office first obtained the data from the Nicholas Jacob Cruz email account, they provide a document that shows the linked accounts, the accounts that are linked both by SMS or text message. When you get a validation text message when you first sign up, they link those accounts by that phone number, and then they also link different accounts based upon your web browser cookie. So that's a small file that's on your computer that tracks your movement around and tells them when the same computer has visited the same website or the same servers over a different period of time. They keep track of all those different accounts, and that's how we identified Linda Cruz 1949.
Okay, Your Honor, at this time, I'd like to end this in authenticity certificate from Google.
Yes, there's also a certificate of authenticity with it.
Your Honor, I'd like to offer State's Exhibit 23K.
Thank you. These are, all of these pages are part of the same composite exhibit?
Yes, one's the authentication.
Is there any objection to the court receiving what's been marked for identification 23K, as in kangaroo?
Yes, Judge, I'll renew all previous objections made today, as well as arguments in D-180, D-218, and D-MIL 10.
Okay, thank you. Over the defense objection states 23K will be received as states 440.
Now, Detective Master showing you State's Exhibit 440. What is this?
These are the Google search history events from the Linda Cruz 1949 at gmail.com account.
Okay. Did you read this for us?
Yes. November 15th, 2017 at 15:16:05 UTC, searched for Stoneman Douglas. November 15th, 2017 at 16:18:20 UTC, searched for Marjorie Stoneman Douglas. November 16th, 2017, 19:29:30 UTC, search for I Want to Kill People. December 23rd, 2017 at 4:41:08 UTC, search for Massacre. December 23rd, 2017 at 4:41:28 UTC, searched for Massacre Killing. December 23rd, 2017, 4:41:46 UTC, searched for Killing People. January 13th, 2018, 16:57:23 UTC, searched for Stoneman Douglas. January 13th, 2018, at 3:25:02, searched for Smith & Wesson M&P 15 Sport 2 firing pin.
Page 2.
January 16th, 2018, at 20:54:14 UTC, searched for school shooting books. January 28th, 2018, 14:51:33 UTC, searched for school shooter test. January 28th, 2018, at 14:44:32 UTC, searched for how to become a school shooter. January 30th, 2018, at 17:50:51 UTC, searched for Aurora shooting victims. January 31st, 2018, at 22:43:36, searched for Aurora massacre. January 31st, 2018, at 23:05:46 UTC, searched for school shooting. February 2nd, 2018, at 14:19:28 UTC, searched for Marjorie Stoneman Douglas. February 2nd, 2018, at 15:11:44 UTC, searched for Marjorie Stoneman Douglas school hours.
Page 3.
February 2nd, 2018, at 15:19:45 UTC, searched for Stoneman Douglas school map. February 3rd, 2018, at 5:49:38 UTC, searched for school shooting. February 7th, 2018, at 1:01:16 seconds UTC, searched for Marjorie Stoneman Douglas. February 7th, 2018, at 13:22:27 UTC, searched for soft guitar case. February 10th, 2018, 23:46:33 UTC, searched for school shooters. February 12th, 2018, 17:40:04 UTC, searched for school shooters. February 12th, 2018, at 17:40:23 UTC, searched for school shooter YouTube.
And page 4.
February 13th, 2018, at 0:125:52 UTC, searched for how long does it take for a cop to show up at a school shooting. February 14th, 2018, at 03:06:22, searched for Marjorie Stoneman Douglas.
this I'm going to show you now. State's Exhibit marked 23G. Ask you, Detective Masters, take a look at this.
These are the YouTube comments that were associated with the Nikolas Cruz Makavor at Gmail account.
Sorry.
Gmail account along with the record certification.
And you compiled those comments?
Yes, I did.
Now I'd like to open out State's Exhibit marked 23G.
Can I get Mr. Sachs just real quick?
Sure, of course. Yeah, that's G.
Other than the objections previously raised, defense, do you have any objection to the court admitting 23G as in George?
No, Justice, the previous objection made earlier this afternoon, as well as renewing arguments from D178, D215, DMIL 10.
Okay. Over the defense objection states Exhibit 23G for identification will be received in its entirety in 441. As 441, excuse me.
I'm going to show you State's Exhibit 441, Detective Masters. Could you tell us what that is?
These are the YouTube comments provided by Google that are associated with the Nikolas Cruz Makavor account.
Okay, could you read that for us, please?
Yes. July 3rd, 2017, at 10:39:54 p.m. UTC. When I turn 21, I am going to kill people. July 3rd, 2017, at 11:45:05 p.m. UTC. In 2020, you will hear me on the news doing this. July 4th, 2017, 12:11:35 a.m. UTC. On the night of my massacre, you are not forgotten, Elliot. May you RIP. July 4th, 2017, 12:35 a.m. UTC. It makes me happy to see people die. With a smiley face emoji. July 4th, 2017, at 12:38:14 a.m. UTC. I love to see the families suffer. July 4th, 2017, at 7:20:57 p.m. UTC. I want to kill people. July 5th, 2017, at 3:27:25 a.m. UTC. I think about killing people though. July 5th, 2017, at 3:47:17 a.m. UTC. I want to kill people.
And showing you Now, Stacy, exhibit mark 23J for identification.
Actually, Mr. Schatz, before you do that, ladies and gentlemen, we're going to take a 15-minute break. Please do not discuss the case. Please leave your notepads on your chairs, and we'll be back with you shortly. Thank you.
All right, so that was some long testimony that we've been hearing from this detective looking at some of Nikolas Cruz's search terms. I think some of the jurors probably wanted to take a break, maybe a bathroom break, as we were listening to this testimony. Some really chilling stuff that he was looking up online, on YouTube. The searches that he was doing showed some planning, Gail.
Well, first of all, he starts out, he's able to search the word massacre. That's where he starts with this YouTube planning. We already talked before the last break about the first two searches that he did. But what this is showing is this cold, calculated, and premeditated. As far back as June 2017, he talks about Elliot Rodger, who was a known killer of women. He talks about him a lot.
Wait, let's listen in quickly about this. Maybe some housekeeping issues.
If you show it to me, I can remember.
Yeah, wait a minute, I'll get it for you. Do you remember which one was? Oh, no, I have it. I have it right here.
One of them was, yeah. But I think this is the.
Is this the next one?
Here you go.
Yes, that's the one.
So there seems to be more than what they've put in.
More evidence that the jury will be looking at.
Should we, Detective Masters, take a break, or you?
I don't think it's necessary. In fact, you might need to hear this. I am going to grant the defense motion and that first 1, 2, 3, 4 lines in the case in chief need to be redacted. However, if it becomes an issue in the defense case, that's a totally different ruling. Ms. Bashman, you understand?
Yes, Your Honor.
Okay.
All right, how about?
So, do you, or you're going to make a copy of it?
If you give us some time, we'll just make a copy without that line there, or we can.
Sure, we have a photocopier, you all don't have one here. Oh, you have one. Oh, so if you need this tape?
We can make it now.
Okay.
Okay.
All right, so we're in recess for 15 minutes now, Detective. You may feel free to.
Okay, so 15-minute recess. We'll take a quick one as well, but they heard some pretty
Really
stunning
nasty.
testimony.
Yeah. Really, really a lot of executive functioning, a lot of mature brain matter, just searching, just trying to be very careful, searching how shootings fail, how much ammunition you need, different ways that people did mass shootings. All these kinds of things really show a ton of stuff. Whatever those 4 lines she just stopped, I'm not sure that they need them. But
they may not even make a difference.
Right, at this point.
Including the fact that the last evidence that we heard was from a Gmail account from presumably Nikolas Cruz's mother, Linda Cruz, who had died November 1st. These searches about shootings and about the map of Marjorie Stoneman Douglas, what are the hours of the school, those searches were done with his mother's account.
Correct.
Just weeks after she died.
Correct. And also, you see that he says in this latest account that they're showing on the YouTube, the Makavor account, it says on July 3rd, in 2020, you will hear me do this.
Chilling stuff.
Chilling stuff.
Court took a quick recess. We will too, and we'll be back in about 15 minutes when they come back. You won't miss a minute. Good afternoon. This is the sentencing of Nikolas Cruz. I'm Janine Stanwood, along with our legal analyst, Gail Levine. Thank you so much for joining us. They're just getting back now from a recess. We've been hearing some pretty gut-wrenching testimony from this detective, showing some of the search terms that Nikolas Cruz did online.
Even I needed that break. That was I don't know any other word to say it, but chilling. Just watching the progression in time, what he was searching and what he was doing.
Shooting at girls, shooting at women, mass shooting, school shooting, this one song, the Pumped Up Kicks song, about a school shooting.
Correct. Going to shoot a girl in the chest.
Which is horrifying, by the way, because we just heard the autopsy of a victim who was shot in the chest. It went on and on for pages of all the things that he was planning, and oddly, not unlike a defendant that killed someone at Palmetto in Miami, Palmetto Bay, he was looking up killers just like him. And he was looking up Elliot Rodger and the Russian murder film and Columbine shooters. And it was interesting. You made an interesting point, Gail. You were saying, the summer before he started sort of, doing these searches and how he hated people and he wanted to be a shooter. And then there was this turning point in the fall where his searches then became like plans almost.
Yes. They were more thoughts, and then they became definitely not just a plan, but really a schedule.
And searching for things like the school hours of MSD.
And I think those searches, I was trying in the break to see what those searches were, and I think you would see, like, there's overhead shots of the school and how the school looked, so he could see egress and entrance and things like that. Really amazing. If he would have put all the work into something else, he could have been useful.
It's really pretty chilling to look at the things that he was searching, and then at some point in the courtroom you see the camera shot. There's a camera shot showing the defense table, and he's sitting there and his head's down. And
well, I think there were some times today that I think he actually was pulling on his hair a bit and was a little bit different. I think that now you see that most of the family members have gone and taken a much longer break. They were really put out by these statements.
Oh, sure.
There were times when I thought some of the victim family members may climb over Mr. Marcus and go straight for him.
It's one thing to hear in medical terms things about your loved one and how they died, and that's gut-wrenching enough. But then to look at the actions of the person who committed that crime and the searches they did and the planning that they made, it's awful.
Yes.
Everyone may be seated and state whenever you're ready. You can continue with your question.
Thank you.
Thank you.
Detective Masters, now I show you State's Exhibit 23J. Ask you if you can identify that.
Yes, sir. It's the Nikolas Cruz Makarov at gmail.com YouTube comments with the business record certification.
And did you compile this?
Yes, I did.
Okay. Your Honor, I'd like to call for State's Exhibit 23J.
Thank you.
Yes, ma'am.
Okay, is there any specific objection other than what was previously raised?
Yes, Judge, just arguments that were made in D-177, D-214, and D-MIL-10.
Okay, over the defense objection, State's Exhibit 23J for identification will be received as 442.
Now I'm going to show you Detective Masters' State's Exhibit 442. And what is this?
These are the YouTube comments from the Nikolas Cruz Makarov Google account.
Okay. How do you link all these accounts to the defendant, Nikolas Jacob Cruz?
So all of these accounts were linked based upon the browser cookies that I had spoken about earlier, where the same web browser or device was utilized to log into each one of these accounts.
Okay. And did you have anything to do with the Uber account?
Yes, I did.
What did you do?
So with the Uber account, I did the initial emergency records request and reviewed that, and that's where the first Nikolas Jacob Cruz at Gmail account came from.
Okay, so based on that information that you originally had, you linked all these other accounts, correct?
Yes, sir.
Okay. All right, so with the Nikolas Cruz Makarov, want to tell us what this says?
Yes, on July 17th, 2017, at 12:57:07 a.m. UTC, the comment was, "They did pretty good. Should have had killed more people. It's more of a two-shot to confirm a kill. It's called double tap. If they would have done that, it would have been more like a 36 kill count, like what happened in McDonald's, but pretty good in all with the weapons they had to." July 26, 2017, 12:22:23 a.m. UTC. I am a level 3 psychopath. Woo ha 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 ha. Blood ha ha ja ja. 2020. July 26, 2017 at 1:18:30 a.m. UTC. May Cho, R.I.P. He's just like me. 2020. You fucking bastards. Fuck society.
Who is Cho, do you know?
He is the shooter from the Virginia Tech massacre.
Okay.
July 26, 2017 at 3:44:11 a.m. UTC. I want to join the Army for the chance to kill people and end life. July 26, 2017 at 6:13:18 p.m. UTC. What a little pussy, you're supposed to do one fucking thing and you only managed to fucking injured one person. You little fucking pussy, I would have killed everyone, not ask a question and kill everyone. July 26, 2017 at 6:15:46 p.m. UTC. No mercy, no questions, always double tap. July 31st, 2017, 4:10:58 a.m. UTC. I already see my future, nothing but loneliness. I wish to keep something in the history books like Eric and Dylan. For that, you will hear me on the news 2020. July 31st, 2017 at 5:23:05 a.m. UTC. I'm going to kill people, 20 people. September 11th, 2017 at 7:03:33 p.m. UTC. I fucking shoot all of them.
And now I'm going to show you State's Exhibit marked 23H. Take a look at that one. See if we can do all that.
Yes, these are the YouTube comments from the Antifa Killer 69 Google account.
Okay. How did you tie in Antifa Killer 69 to Nikolas Cruz?
Utilizing the same method with the same document from the Nikolas Jacob Cruz Gmail account, where they listed the matching phone numbers for the SMS connection as well as the web browser cookie.
Okay. And I forgot to ask you about Linda Cruz, 1949. How did you link that to Nikolas Cruz?
That was through the same method. That was also linked through the browser cookie.
And do you know who Linda Cruz is?
The defendant's stepmother, I believe.
Okay. And do you know when she passed away?
I believe it was November 1st of 2017.
Okay. All right, so with State's Exhibit Antifa Killer, did you compile that?
I did.
Okay. I'd like to offer State's Exhibit 23H.
Thank you. Okay, is there any objection?
Yes, Judge. Just renew previous objections from earlier today, as well as arguments in D-178, D-215, and D-MIL-10.
Okay, over the defense objection, the state's composite 23H will be received in part in its current form as 443.
The 443, State's Exhibit 443, Detective Masters. Show it to you right now. What is that?
These are the YouTube comments provided by Google, which associate with the Antifa Killer 69 Google account.
Okay, could you read that for us?
October 31st, 2017, at 9:16:32 p.m. UTC. It's over. My time is almost here. Fuck all of you. Fuck you all. Muahahahaha. I hope I kill you all. October 23rd, 2017, 11:26:09 p.m. UTC. I just hate people in general. October 23rd, 2017, 9:29:04 p.m. UTC. I'm a mass murderer. I'm a mass murderer with interesting thoughts of death and destruction.
And State's Exhibit Mark 23I. For identification, Detective Master, take a look at that.
Yes, this is the Google search history for Nikolas Cruz Makarov.
Okay. And how did you tie that to Nikolas Cruz?
Through the same method with the web browser cookie and the SMS.
Okay. And did you compile that?
I did.
Okay. And it has the authenticity certificate from Google?
It does.
Your Honor, at this time I'd like to offer State's Exhibit 23I.
Okay, is there any objection?
Yes, Judge. Previous objections that were made earlier today, and the D numbers have already been placed on the record.
Okay. Over the defense objection, state's composite exhibit 23I will be received as 444.
Detective Masters, now show you State's Exhibit 444. What is this?
These are the Google search history events for Nikolas Cruz Makarov at gmail.com.
Okay. And would you read that to us, please?
July 7th, 2017 at 17:09:11 UTC. Search for AR-15 mags. July 15th, 2017 at 5:45:55 UTC. Search for movie theater massacre gun. July 16, 2017, 1941-13 UTC, search for movie theater massacre gun. July 21st, 2017, at 2:52:43 UTC, search for gun case cost. July 26, 2017, at 1:25:14 UTC, search for Virginia Tech massacre.
Thank you, Detective Masters. Your Honor, I have no further questions of this witness.
Defense, do you have any questions? Yes, Judge briefly. Okay.
Good afternoon, Detective.
Good afternoon, ma'am.
None of Mr. Cruz's accounts were set to a private, correct?
What do you mean set to private?
None of his social media accounts or Gmail accounts were set under a privacy setting.
I'm not sure of the other. There's no privacy settings really for
Google.
Gmail accounts, right? The searches are held on the back end.
Okay. What about YouTube?
The YouTube comments are publicly available.
Okay. And that's different than searches, right? Searches aren't always publicly available, correct?
Correct.
Okay. And when Mr. Cruz was posting on the YouTube comments, in many of his Gmail accounts, he used his real name.
On the Gmail accounts we just covered, yes.
Yes. And would you agree with me that Mr. Cruz spells his first name, Nikolas, in a different manner than most people do?
Yes. Well, it's different than the spelling of my name, yes.
Right. Are you aware of whether Google or YouTube or anyone else monitors searches and comments for possible threats?
I'm not aware of anything that they do, no.
Okay. I'm going to show you States 443. If I can figure out how to use this. Can you see that, Detective?
Yes, ma'am.
Okay. And you had read off the October 31st, 2017 comment there, correct?
Yeah.
On direct?
Yes, ma'am.
And you were aware that when this comment was made, Mr. Cruz's mother was in the hospital dying and in fact died less than 24 hours later?
Yes, I'm aware of that.
Okay. A moment, Your Honor.
Sure.
Thank you, Detective.
Thank you.
Steve, do you have anything else for us?
No, thank you, Your Honor.
Okay, thank you, sir.
I'm
You're
sorry.
excused. That's okay. Okay, ladies and gentlemen, I have good news. Hopefully it's good news. We're going to, that's the last witness that the state has prepared for today. So we are going to recess early. You all have been given, or you should have been given, a letter which is signed by me indicating you were here this week and that you're required to be back on Monday. You will notice that the time is 30 minutes later on your calendar, so Monday, Tuesday, Wednesday of next week, you don't have to be here until 9 o'clock. Please take the calendar with you, and then Thursday, we need you here a little bit early. That's also on the calendar. I will remind you each day of that. Other than that, please remember that when we are in recesses, you may not discuss the case with anyone, including friends or family members. You may not try to look up information about the case or the people and places involved. Do not permit anyone to say anything to you or in your presence about this case, and if anyone attempts to say something to you about the case, tell the person to stop and report the matter immediately. Thank you all very much for your time and attention. Have a safe drive home, and I will see you back on Monday morning. Please leave your notepads behind. Thank you.
So this is the end of week 2 for the sentencing of Parkland shooter Nikolas Cruz, and the state ended today with a witness who is a Broward Sheriff's deputy who specializes in internet and searches, and he showed us basically the things that Nikolas Cruz was searching online and the comments that he was making on YouTube.
Yeah, this was just not a short period of time where he searched. He started searching in June of 2017 about massacres. And massacre after massacre, he searched and he researched under many different...
Similar to the one.
Let's stand by quickly just to see what this
He's
is.
available today. He has confirmed, has attempted to confirm with both offices. He's confirmed with BSO, and he was going to, it was set for 4 because I wasn't exactly sure when we were going to be done, but I can ask him. Hold on one second. Okay, he can do it when you all finish up here. We can go straight, I think he's on 20th floor. I assume you all are available since we finished.
Mr. Weeks.
Okay, and he said if the state could let Mr. Pryor know, because he was confirmed for 4 o'clock, and then he asked me to let Tony with BSO know because he was also confirmed for 4 o'clock. So why don't we, it's 3:02 now, why don't we aim for about 3:15? That'll give everyone an opportunity to gather their belongings, okay?
Sure.
Thank you. Other than that, we're in recess.
So my colleague Christina Vasquez and I, we've been messaging, and she's wondering if maybe there will be a meeting about the jury visit to the 1200 building, how that's going to work. She mentioned BSO and Sheriff Tony, which makes sense because the Broward Sheriff's Office will have to coordinate to try to get all of those jurors out and figuring out how to get the defendant out because of his right to be there.
Correct. There's a lot of logistics there. There's a lot of people that have to be in the right place at the right time, at the exact time. There's a security risk for everyone involved, everyone.
So that said, Gail, going back to what we were just listening to, these searches that Nikolas Cruz made online, the comments on YouTube, this started in the summer before the shooting.
It certainly did. And what that shows is the aggravator of cold, calculated, and premeditated. It's not to show anything except that he meets another aggravator, not just that he killed 17 people, not that he attempted to kill 17 people and battered a law enforcement officer, but he did this in a cold, calculated, and premeditated way. He used aliases on his YouTube account, one of which is Makavor, which I think is something from Call of Duty, and also the name of a Russian semi-automatic gun. He used Antifa Killer. He really worked hard at doing his research as to what he wanted to do and make sure that he did it well.
And he was specific about it. So he was looking up particular school shootings and other massacres that had happened, and he had used the word massacre. He was also looking up types of ammunition. He was looking up, I believe it was the Smith & Wesson weapon that he used, the AR-style rifle. He was looking up details about that.
He was commenting on people that only killed one person, that he was watching something and called them a nasty name for not killing more. He talked about double tap, used double tap. That's a kind of ammunition that's very powerful. He just was very methodical, and that is very difficult for him to overcome a mental impairment. He calls himself a psychopath, which is not a mental disease. It is a mental way you act and means you're evil.
You've been a prosecutor for a long time in this modern age of internet and how nothing really goes away. What you do on the internet stays online for a long time. Is this something typical for prosecutors to look up, the search history of a defendant to show maybe planning or state of mind?
I think it has become more relevant now. They did a great job. They really did. And they were able to get lots of stuff. I don't know whether in 2015 you would have been able to do it, but they were able to do it from 2018, and they did it. I do want to comment. I thought that the public defender, unfortunately I don't recall her name, but she did try and make a dent in something. I guess she wasn't going to let it go. And she outlined something that, of course, was a heart-wrenching statement that he made in a comment.
It was a comment that he made, and I tried to take some notes of it. Of course, it's the F word, so
Right.
you know they can say it. I'm not going to say it, but basically, it's October 1st. It is hours before Cruz's mother died.
Yes.
And he says it's over. My time is almost over. F you all, and it's this very inflammatory and exclamation points.
Right.
So the defense attorney gets up and says, by the way, this was right before his mother died. So is she indicating that this was like a cry for help, or
Yeah, the problem is that he makes a lot of really terrible statements if you put them all side to side prior to his mother dying in the beginning of the summer, and whether she's sick or whether this is bad, he doesn't say anything about the mom. He says, this is about me. I'm a psychopath. I like to kill. I like to watch people suffer. That is really telling about who he is.
And in the audience, we saw the members of different victims' families. We saw the Guttenbergs earlier. We saw Max Schachter, some family members who have been there from the beginning, and just the looks on their faces as these things are read. It's
pure disgust for them. It's just unconscionable, and they just can't even imagine it. I think that the small attempt at complaining to Google that you didn't get him before was sort of lost in the plethora of horrible statements that he made. Just horrible.
So next week we still have, and as we're watching this video now, as court wraps up, you can see if we can take this shot. That's Nikolas Cruz. He's finally being let out of the courtroom right now by deputies. Court is done for the day. The question is, what happens next week? There are still autopsies that we have not heard about from 3, I believe, of the other victims. We heard Carol Loughran's today, and I'm guessing, Gail, that was strategy on the state's part because she was a female victim, 14 years old, and she was shot in the chest. And what did we hear afterwards?
Correct.
We heard from Nikolas Cruz himself in a comment that he was looking up how to shoot a girl in the chest.
Right, and being very, very, very enthralled with Elliot Rodger, who was a female killer, a killer that killed women, a misogyny killer, they called him. So I think that that's horrific. I think if I was to guess, maybe they get the 3 autopsies done and end it with the jury view.
Well, they have a lot to think about, not only this weekend, but it's only Wednesday. So Thursday, Friday, and the whole weekend, jurors now have to think about what they saw this week.
That's right. And then, of course, they will be left. I think there'll be a break